ನಾಲ್ಕನೇ ನಂಬರ್ ಇದೆ ಸರ್.
ಅದು ನಿನ್ನೆ ಮಾಡಿದ್ದು ಬಂದಿಲ್ಲ.
ಶ್ರೀರಾಮ್, ಮಂಡೆಯಿಂದ ವಿಡ್ರಾಲಿಂಗ್ ಮಾಡಕತ್ತೀನಿ, ಇನ್ನೂ ಪೋಸ್ಟ್ ಆಗೋಲ್ತು. ನಾನು ಈಗ ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ, ಸಾಕಾಗೋಗಿದೆ ನನಗೆ. ಕೊಟ್ಟಿದೆ ಎಲ್ಲಾನು ನಿನ್ನೆ. ಇದು 4ನೇ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತಾ ಇರೋದು. ಹೌದು, ಸಾಕಾಗೋಗಿದೆ. ಎಷ್ಟಂತ ಇವ್ರಿಂದ ಓಡಾಡೋದು ನಾವು. ಹೌದಾ? ಶ್ರೀರಾಮ್ ನಾ ಇಲ್ಲ, ಇವತ್ತು ಮೆನ್ಷನ್ ಮಾಡ್ತೀನಿ, ಸಾಕಾಗೋಗಿದೆ ನನಗೆ. ಮಂಡೇ, ಟ್ಯೂಸ್ಡೇ, ವೆನ್ಸ್ಡೇ ಅಲ್ಲ, ಇದನ್ನ ಬೋರ್ಡ್ ವರೆಗೂ ಕಳಿಸಿದ್ವಿ ನಿನ್ನೆ.
ಬೋರ್ಡ್ ಅಲ್ಲಿ ಇದೆಯಾ? ಅಲ್ಲ, ಪೋಸ್ಟಿಂಗ್
ಅರ್ಜೆಂಟ್ ಇದೆ, ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್. ಮೂವ್ ಮಾಡ್ಲೇ ಬೇಡ, ನಡೀತದ. ನಾಳೆ ಬರ್ಬೇಕು.
ಶ್ರೀರಾಮ್ ನಮ್ದು ಸ್ವಲ್ಪ ಹೇಳ್ರಿ.
ಮುಗಿಲಿಲ್ಲ ಅಂದ್ರೆ
4ನೇ IA1 ಬಂದಂತ ಏನು ಆಫೀಸ್ ಆಬ್ಜೆಕ್ಷನ್
ಇಲ್ಲಿ ಬರ್ತಾರೆ, ಹೇಳಿ ಮೆನ್ಷನ್ ಮಾಡ್ಕೊಡ್ತಾರೆ. ಶ್ರೀರಾಮ್ ಸರ್, ಶ್ರೀರಾಮ್ ಸರ್,
ಇಂಗ್ಲಿಷ್ ಬೆಳಗ್ಗೆ ಮೆನ್ಷನಿಂಗ್ ಇಲ್ಲ.
ಐ ಥಿಂಕ್ ಸೊ.
ಕಾಪಿ ಒಂದು ಸರ್ವಿಸ್ ಮಾಡ್ಬಿಡಿ. ಕಾಪಿ ಒಂದು ಸರ್ವಿಸ್.
ಶ್ರೀರಾಮ್ ಸರ್, ನಾಳೆ ಡಿಸ್ಪೋಸ್
ಸರ್ ಇದು ಸರ್ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಈ ಮ್ಯಾಟರ್ ಅದರಲ್ಲಿ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಆಗಿದೆ, ಎಷ್ಟಾಗಿದೆ? 2 ಅಲ್ಲಿ 2 ಪಾಯಿಂಟ್ ಎಷ್ಟು ಗೊತ್ತಾಗಲ್ಲ ನಮ್ಗೆ. 100,784
0.9 ಸರ್. ಅದೇ
ಹಿಂಗೆ ಬಂದಲ್ಲ.
ನಮಸ್ಕಾರ.
ಇದು
ಗುಡ್.
ನಿಮ್ ತಗೊಂಡ್ರೆ ನಾಳೆದು ಮೆಮೊ ತೊಗೊಳ್ತಾರಲ್ಲ ನಾಳೆದು. ಶ್ರೀರಾಮ್ ಇದ್ದಾಗ ನಮ್ಗೇನು ತೊಂದರೆ ಇಲ್ಲ. ಶ್ರೀರಾಮ್ ನೇತ್ರ ರಾಮ ಮಂದಿರ ಆಗಿತ್ತು.
ನಾಲ್ಕು ಸ್ವಲ್ಪ ಕಡೆ ಬರಲಿ ಮೆಮೊ ಐತೆ. RFI ಬಾಯ್ RSI.
ಟೋಟಲ್ ನಂಬರ್ 4 ಬರ್ಕೋರಿ ನಂದು.
ಕೊಟ್ಟಿನಿ.
ಅಲ್ಲ 8 ಹತ್ತು ಬರ್ದಿನ ಮೇಲೆ.
ಅದೇ 4 ಬರೋ ಕೊಟ್ಟಿನಿ.
ಇದೇನು?
ಇದು 2 ಕೊಟ್ಟಾಗ ಇದು 7 ಕೊಟ್ರಿ ಯಾರು ಸರ್?
ಗೊತ್ತಾಯ್ತು.
And permission. One matter, 230. Lord, this is matter pertaining to Lord Kuke Subramanian matter. My Lord already heard the matter and given a date today, but it's not listed. Lord,
How can it come at 2:30? File ಬರ್ಬೇಕಲ್ಲ. You can't ask for a
interim order not till today, Lord.
till next date.
Next date of hearing, matter listed today, but
Next date of hearing list ಆಗೋವರೆಗೂ
Date.
next date of hearing. File ಬರುತ್ತೆ. You can't move it without the file. ಯಾಕೆ ಫೈಲ್ ಯಾಕೆ ಬಂದಿಲ್ಲ? ಚೆಕ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಬೆಂಗಳೂರು ಫೈಲ್ಸ್ ಎಲ್ಲ ಡೇಟೆಡ್ ಫೈಲ್ಸ್ ಬರಬೇಕಲ್ಲ.
if it is
ಡಿಲೇ
filed,
ಆಗಿರ್ಬೇಕು. ಬರುತ್ತೆ ಲಿಸ್ಟ್ ಆಗುತ್ತೆ.
Lord, 230 I will mention, Lord. If Lord senior counsel came, Lord, if not tomorrow, Lord, I will mention it.
If senior counsel has come without the file being listed, that is his problem, not our problem.
Yes.
Don't please make this kind of submission.
Sorry.
Don't make us observe things which you won't like.
Sorry.
Mentioning for an adjournment.
Memo ಏನಾದ್ರು ಇದೆಯಾ? ತಗೊಳ್ಳಿ. Allotment.
Adjournments. Oops. List number 1, 818, 48 to 52. 819.
Serial number 49. Once adjournment is
Kindly short recommendation, my lords.
B group
adjournment.
2011.
Please, my lords. Senior is out of station, my lords.
ನೀವು ಯಾರಿಗೆ?
I am for prisoner, my lords. Shrikant T. Patel.
Respondent ಗೆ? Have you informed the respondent?
Yes, my lords. Yes, my lords.
49 at the request of counsel for the petitioner, relist on 23rd January. It is made clear that no further adjournment would be granted if arguments are not advanced on that date. Petition will be liable to be dismissed for non-prosecution.
Please, my lords.
819, 53 to 56.
Not serial number 55 minutes. May I request it for 2 days accommodation? 2 days accommodation.
They appear for the respondent in that they have not amended the cause title or they have brought the LRs on record. For that reason, we have moved the matter.
I request it on Monday, my lord.
Who is expired?
My lord, respond number 1. The LRs are not brought on record.
Respond number 1A and 1B ಬಂದಿದ್ದಾರಲ್ಲಪ್ಪ.
No, my lord. There is one more LR which needs to be brought on record. They have not.
That is their choice. You appear for that other LR,
Please.
then you file application. As long as 2 of them are there, they can represent the estate. At the request of counsel for the petitioner, relist on 23rd. It is made clear that no further adjournment will be granted if arguments are not advanced.
Please.
23rd.
No, not yet.
Page 20, 57 to 63. Page 21, 64 to 70.
Serial number 70, my lord. I prefer for petition, my lord. Short accommodation.
Inform ಮಾಡಿದಿರಾ respondent? 70 at the request of, who has moved the matter?
Myself.
Fast.
An endorsement has been received, and that is also part of the request. That they are not challenging.
ಅಲ್ಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡ್ಬಿಟ್ಟು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳ್ತೀರಾ?
ಪರ್ಸನಲ್ ಇನ್ಫಾರ್ಮೇಶನ್
ಕಾಪಿ ನಾಟ್ ಅಟ್ ಸರ್ವಿಸ್.
ಏನ್ ಕಾಪಿ ನಾಟ್ ರಿಸೀವ್?
ಕೊಟ್ಟಿದ್ವಿ.
ಇಲ್ಲ.
ಫಿಲ್ಟರ್ ಕೊಡಿ.
ಅಪಿಯರ್ ಫಾರ್ CGSC ಮೇಲೆ.
ಇವಾಗ ಕಾಸ್ಟ್ ಎಷ್ಟು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿದ್ದಕ್ಕೆ? ಆಮೇಲೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೇಳೋದಕ್ಕೆ ಏನಕ್ಕೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಏನಕ್ಕೆ ಬೇಕು?
ಸೀನಿಯರ್ ನಾಟ್ ಫಿಲ್ಲಿಂಗ್ ವೆಲ್.
70 at the request of counsel for the petitioner released on 24th, learned AGA submits that the the release which have been sought for being only a mandamus, there being an endorsement already issued, the writ petition is not maintainable. Counsel for the petitioner seeks for and is granted a week's time to obtain instruction, make a submission. Released on 24th.
Please.
65 minutes, serial number.
65.
Please, my lord. You grant 2 weeks time, my lord.
ನೀವು ಯಾರಿಗೆ
Opponent, my lord.
petitioner ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
Please, they have informed.
65 at the request of counsel for the ಇದು court all moved.
That's, we have moved the matter, but they told.
Did you inform them before moving?
That's last one.
You next time when you move,
Please,
inform the other side counsel
please.
so that they'll get ready. Otherwise, sumne list ಮಾಡಿ it will get adjourned.
I have 66.
The request of counsel for the respondent released on 24th.
66, my lord. Lords, I have a submission to make. But serial number 55 sought adjournment. Interim order is going to kindly be extended. Serial number 55.
55 interim order ಆಗಿದೆ.
Please.
Interim order ಆಗಿಲ್ಲ, sorry, interim order extended.
Your serial number 66, my lord. Similar matter, my lord.
65, 66
Please,
connect.
my lord.
Connect ಮಾಡದ?
It may be connected.
65 and 66 connect to each other, released on 24th.
Page 22, 71 to 76. 71, my lord. For the petition, my lord. Last time I read one judgment, my lord, but the late petition has demanded the matter. I mean, such other judgment on revenue inspector has no power to.
71 at the request of counsel for the petition released on 25th.
Page 23, 77 to 84.
79, your lordships.
Yes.
Appear for respond number 2 to 5. Petitioner counsel is present, my lords. Seek for a short accommodation, my lords.
CPC. Again, the court all moved.
It was moved.
Next time, again, 79 at the request of counsel for respond number 2 and 2 to 5.
2 to 5.
Released on 24th.
Interim order, my lords.
Order earlier granted is extended.
Okay. Grateful.
Page 24, 85 to 90. Page 25, 91 to 95.
Serial number 94 I appear for
90?
94
Yes.
I appear for the petitioner. Yesterday I have filed for application seeking amendment of the writ petition for the reason that during pendency of this writ petition, the municipal council has passed a demolition order. By way of amendment, I am challenging that order.
It's not been put up.
It is not.
Sir, see application, sir. It'll come.
Please.
Page 26, 96.
Milords, may I make a mention? This was a date given, time given matter. It's regarding the elevated highway Jakkur Road, my lord. The date was given as today, time is 2:30. I ascertained from the section in Bangalore that the file has been dispatched before booking my tickets, but the matter has not got listed. And I've given the court officer number, he's inquiring, my lord.
It will be listed tomorrow.
My lord, I request.
Listed at 2:30.
My lord, I request on 20th, my lord. Bidan Chandran has requested that he will be physically present in this matter.
We can't even give a date because there's no file.
No, he may.
File ಬಂದ್ರೆ ತಾನೇ date ಕೊಡೋದು.
ಅವರಿಗೆ ಒಂದು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರೆ ನಮ್ಮ.
File ಬಂದಿದ್ರೆ we'll list it tomorrow and adjourn it to 20th.
Please.
May I request if, because I'm unable to trace the file, my lord. They say it's come here, but it's not here. So,
You want us to go and trace the file?
no, my lord. I have no powers to.
It will come.
Okay.
Please. When files are transferred, it will be in transit somewhere, it come.
Fine.
Serial number 42, B group hearing, sir. Short time may be accommodated because counsel for 42, sir. B group hearing. I am for one of the respondent. Kindly short date may be accommodated because counsel is not keeping.
You not even filed wakala.
Mohammed
ನೀವು 42 107277.
Yes.
Respondent ಯಾರು ಇಲ್ಲ ಇಲ್ಲಿ.
Sorry, 41, sir. 41.
MB Kanvi.
Yes, Allah.
ಯಾವ ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ಬನ್ನಿ. ಶುರು ಮಾಡಿ.
May I request cell number 63. I appear for 3 years
Yes.
for petitioner.
Have you informed the respondent?
Yes,
At the request of counsel for the petitioner, relist on 23rd.
please. Highly obliged.
Service have been moved in. ಯಾರು respond number 1 ಯಾರು?
ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿದೀನ ಮಾತ್ರ ಬೇಡ.
HBC project.
Please.
SLO HBC project.
Yes.
ನೀರಾವರಿ ನಿಗಮ್ ಲಿಮಿಟೆಡ್.
ಹೌದು, ನೀರಾವರಿ ನಿಗಮ್ ಅಂದ್ರೆ ದೇರ್ ಇಸ್.
SLO ನೀವು ಬರಬೇಕು.
ಹೌದು, SLA ನಾವೇ ಬರ್ತೀವಿ.
And AG accepts notice for respond number 1, counsel for the petitioner to furnish 2 sets of the petition along with annexures on relevant AGA. ಇವಾಗ ಯಾರು who is appearing? Shivraj Bellikaino, RM Kulkarni. Shivraj S. Bellaki has entered appearance for respond number 2. Registry is direct. Delete the name of Shri RM Kulkarni as that appearing for respond number 2. Relist on 25th January.
2 Shivraj Bellaki.
Before petitioner, redetermination of compensation under section 28A, my lord, this is covered by your lordship's judgment.
Please, my lord, I appear for the petitioner in 2.11.
Yes.
And 2.14 and 2.15 as submitted by senior, my lord, this is covered by your lordship's judgment in MSA 200.
2.10 are by the Niravari Nigam.
Yes, it is connected with 2.7.
is by the land loser. 2.12 Konkan Railway bare bandida.
Let's appear
They are
for
all connected, my lord. 2.11 is by the land loser. In spite of an award under 28A, my lord, passed in 2022, the compensation has not yet been deposited. Hence, we filed a writ seeking a direction. Thereafter, my lord, after nearly 9 months, the Konkan Railway filed the writ petition, appealing the award under 28A, which is at 2.14 and 2.15.
Yes, Mr. I.
let's say appear for the Konkan Railway Corporation, which is also a respondent in the first matter, that is 2.1.
2.11.
2.11. 2.1, 4 and 5 are filed by the Konkan Railway, challenging the award made under section 28A.
First question that we have is, there is one set of matters where the KNNL Niravari Nigam is there.
That is a case.
To Konkan Railway.
That is a case in which there was an earlier point of time a writ petition filed. Matter was remanded back on the short issue, wherein the court had directed them to examine whether the delay caused in disposal of the application is on account of some default by the authorities. Should there be saddling of the interest on the beneficiary on such situation? But unfortunately, even after the remand, I am told, I have not gone through the order or impugned there, that they have not decided. So they apparently are dependent on the decision in the Konkan Railway case, where similar issue has been raised.
Same acquisition there. It's only the issue which is
Similar issue, but different acquisition. May I just pass on the propositions?
all these have been clubbed because there is a similar issue.
Similar issue. Let's, in my case.
1.1, 2.14 and 2.15 are connected.
Yes, let's, 4 issues arise for your lordship's consideration. Why don't you give it?
May I submit, my lord? I will only take, well, not more than 1 minute.
Now there is another counsel submitting. Once he finishes, you can do that.
I'm sorry, because 2.11 was my matter. I'm sorry.
It's four propositions which require to be considered at your lordship's hands. Whether a writ petition would lie to enforce the payment of an award made under section 28A, while an equally efficacious remedy by way of execution under order 21 is available. In the circumstances of a suo motu review by the assistant commissioner, revising and enhancing the compensation payable worked out under attached calculation sheet under section 28A is permissible, when the law under Land Acquisition Act does not provide for any such review by the authority. Third is, under section 28A, the law mandating filing of an application within 3 months of the award by the reference court under section 18 in respect of similar land, whether while entertaining the application beyond 3 months, the authorities could factor in the additional time taken without establishing or producing a certified copy of the application so as to determine the time taken in obtaining the certified copy of the award by the reference court in terms of proviso to section 28A, or is the application filed by the respondent's petitioners is time barred. Whether in the absence of a provision for payment of interest under section 28A, is such interest payable, and if so, there is a not delay of as much as 12 years in making the award under section 28 for no fault of the beneficiary payable to be saddled by whom. The fourth one is, Lords, something which was directed to be considered in the connected writ petition, that is Niravari Nigam case. Rest of it, I don't know, I'm not aware of, but I'm told the last proposition has a bearing on the liability who is to be saddled, which was directed to be considered in the previous proceedings of the Niravari Nigam.
Who is appearing for the Niravari Nigam?
Similar issues, my lord. Avoiding interest in section 34.
So you'll adopt the submissions made by Mr. Nayak for you.
We also engage senior counsel. He is not available today, but will not repeat. It is covered, my lord, will not repeat.
Do you want an adjournment or shall we take it up? ಆಮೇಲೆ argument ಆದ್ಮೇಲೆ ಅದಕ್ಕೆ ಮಾತ್ರ adjournment ಕೇಳಬೇಡಿ. Are you going to adopt Mr. Nayak's submission? Because Mr. Murthy's submission would be contrary to that.
Yes, well, he is opposing me.
And Mr. Murthy would be on this side.
Yes. Let's, I'm only thinking loud. I saw 26 pages of causes before your lordships, and your lordships probably have a different list at 2:30. So if it is to be heard, I'm ready. I'm not saying I'm not ready.
How long will you take?
It should take, Lords, I have 4 or 5 judgments to be taken through.
How long will you take?
About an hour and a half. About an hour and a half.
An hour and a half.
Yes.
Mr. Murthy, how long will you take?
I will take not more than 5 minutes, my lord,
Not more than
because
5
it is covered by your lordship's judgment. Now
So
I
you'll
think
get only 5 minutes, don't worry. Patil?
means if your lordship is convinced with
5
me,
minutes, hai na? So
Covered by your lordship
10
judgment.
minutes. So you have an uphill task.
Yes, my lords. If
For
it is,
31
if they are
years,
so
my lord.
confident of having been covered, if I'm not mistaken, it is an MSA.
Yes, MSc, exactly.
No, that has
Your
no
lordship's
bearing on this.
judgment, I have
That's
given
not
the
the
memo
issue regarding
of,
Point number 3 is covered by that judgment.
yes.
Point number 1, 2, and 4 may not be covered by that judgment. So that will have to be.
In fact, my lord, it is, I would submit, respectfully submit, it will cover.
A larger question which has been raised, Lord, it is not, Lord, connected to our claims. So our claim is covered by your lordship judgment, and that may be decided.
Limitation will probably be covered by 3.
Yes.
You got this proposition?
Yes.
So give him a copy.
ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹೌದು, ಇಲ್ಲಿದೆ.
Proposition 3 may be covered.
Yes.
But we'll also have to answer the question of interest. Because ಬರೀ ಅಷ್ಟೇ ತಗೊಂಡು interest ಬೇಡ ಅಂದ್ರೆ, if you don't want interest, we'll record your submission.
Yes,
We don't
my
need to
lords.
answer that question.
No, my lord.
May I, my lord, interject and assist your
Mr.
lordship?
Murthy, why are you interjecting so many times?
I'm sorry.
So far as this case is concerned, my lord, your lordship, ultimately, the only question that redetermination of compensation and section 28A.
Are you interested in interest?
Interest also, my lord, we are,
Then we'll have to answer point number 4. If you make a submission that you want only the compensation and no interest, then we don't need to get to 4. This 4 has not been dealt with, as far as we remember, it's not dealt with in that judgment. So 1, 2 and 3, 1, 2 and 4, subject to what Ms. Nayak argues on point number 3. So 1.5 hours. You want to come on a Saturday, 25th? 25th Saturday is a working day.
Very well. It's okay.
25th. Mr. Murthy, 25th.
Please, my lord.
Mr. Bedaki,
Please,
at the request of all the councils, relist on 25th. Again, why is it come in orders? First serial number 6, comply madila ನೀವು.
Let's, whatever office objections are there, we'll comply with in the meantime.
And in both your matters, there is compliance to be made.
Yes, let's say minor ones may not have any. Will
Relist on 25th. In the meanwhile, compliance with the office objection in the concerned matters to be completed.
Lordship, please.
Both the councils to exchange their respective synopses of dates and events, list of authorities along with authorities, all the councils,
Please.
With each other.
Lordship, please.
ಅದಕ್ಕೂ date fix ಮಾಡೋಣ on or before 17th January.
Lordship.
Grateful.
My lord, in this MV Remote has given no objection. Name
no
has to be
objection.
deleted. SN Bankar will
I
appear.
have filed Wakalat, my lord. I pray for short time to comply the office.
Officer has entered appearance. Registry is direct delete the name of Shri MV Remote. Learned counsel for the petitioner seeks for and is granted 10 days time to comply with the office objection. Notice here, who are the respondents?
The serial number 34 and 35.
3 ಮಾಡಿ first.
I'll comply short date.
ಮಾಡಿ. Who are the respondents?
1 to 4 for state.
And AG accepts notice for respond number 1 to 4. Notice to respond number 5 to 7 is deferred for now. Relist on 24th January.
Please, ma'am.
4 GB9.
Lordship, in this case,
What
there
is
are
IA1
two
of
office objections
24,
on the IA.
ಏನದು?
Actually, what happened, the respond number 6 died prior to filing of this petition, subsequent to the order of the tribunal. So I filed an application to bring the LRs on the record by filing application under 1 Rule 10(2). Nothing was pending when he died.
Why do you file application without serving on the other side?
Through oversight, one person.
ಇವತ್ತು ಟೆಲಿಗ್ರಾಮ್ ಅಲ್ಲಿ ಸರ್ಕ್ಯುಲರ್ ಹಾಕಿದ್ದಾರೆ.
I'm sorry for that.
Any objection? You're appearing for Mr. Badalli.
Yes, sir.
Any objection to this IA for bringing LRs?
No, man.
The counsel for the petitioner has today served copy of IA 1 of 24 on the counsel for the respondent. Hence, office objection raised thereon does not survive for consideration. During the pendency of the above matter, respond number 6 has expired.
Yes.
You notice respond number 6 nim client na issue notice on IA 1 of 24 returnable by 5th March.
Please.
Process fee and copies to be furnished by end of day 13th, 15th January. You appear for the defendant number 1.
Please, ma'am.
Why are you filing so many applications before the trial court? 4 months are dispose madu anmele, you have filed 8 applications. You don't want the disposal to happen.
No, my lords.
8 applications you have filed after the direction was issued by this court.
Sorry, my lords, I will, since I don't have any instructions, kindly pass over, my lords, I will.
And the court has allowed your applications for recall some 3 times or 3 different witnesses. If you can't do the cross-examination at one go, then there's no point in doing it. A letter dated 16/12/2024 of the first additional senior civil judge Gokak has been forwarded by the by the principal district and session judge Belgavi. A perusal of the said letter indicates that after the order dated 12/8/24 passed by this court in WP 104552 of 2023 for disposal of the suit within 4 months, defendant number 1 and defendant number 2 have filed several applications resulting in the delay in the disposal. The case is now stated to be posted for arguments. It is made clear that no other application filed by any of the parties shall be entertained by the trial court and the matter be proceeded with for arguments, and the trial court dispose of the said suit within the 1 month time requested for by the first additional senior civil judge Gokak. Please.
Please, oblige.
Hello.
6, CS sector.
Sincere apologies, my lords. 2 days accommodation may kindly be granted. We will file the application for substitute.
The counsel for the petitioner seeks for and is granted a week's time to file necessary application to bring the necessary application take out sub-service by way of paper publication. Relist on 20th.
Oblige, my lords.
7, Mrutyunjay Tata Bank.
Weeks time I've granted.
Records are not received, Your Lordship. Records are not received.
I'll take first steps in respect of.
R7 and 8.
Please.
Office objection to comply madilla.
Please.
Counsel for the petitioner seeks for and is granted 10 days time to comply with the office objection. If the office objection is not complied by 22nd, the petition would be liable to be dismissed for non-prosecution. Counsel for the petitioner also seeks for and is granted 10 days time to make payment of necessary process fee and furnishing copies as regards unserved respond number 7 and 8. If needful is done by 22nd, registry is directed to issue notice to unserved respond number 7 and 8, returnable by 19th March. If needful is not done by 22nd, relist on 27th for dismissal.
Interim order kindly be.
Interim order earlier granted is extended till next day.
Government kindly be secure records. Government kindly be.
ಇದು ಮುಗಿಸಿ ಅವ್ರು ತಗೊಂಡ್ ಬಂದು ಅವ್ರ ಹತ್ರನೇ ಇಟ್ಕೊಳ್ಬೇಕು.
Please.
Service ಮುಗಿಸಿ.
8, Shuraj Balloli.
My lord, in this case, in the last occasion, the respondent number 1, he himself personally appeared and seek a time to engage a counsel.
ಅವ್ರ ಹೆಸರು ಬರ್ದಿಲ್ವಲ್ಲಪ್ಪ. Relist on 2nd week of January. Registry is directed to print the name of respondent number 1 in the cause list and relist on 27th January.
Please.
9, Jagdish Patil.
There are office objections, my lord. Weeks time to comply, man.
Counsel for the petitioner seeks for and is granted 10 days time to comply with the office objection. If not complied with by 22nd, petition would be liable to be dismissed for non-prosecution, relist on 25th.
Obligation.
10 Jagdish Patil.
In this also, my
Iಷ್ಟು
lords.
objection ಇಟ್ಕೊಂಡು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮೂವ್ ಮಾಡಿ ಲಿಸ್ಟ್ ಮಾಡಿ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ. We start imposing costs on this.
Last,
You made 12 people work to list this file. And you are making 1, 2, 3, 4 people to adjourn it.
inadvertence, my lord.
Last 10 days time, by 22nd, if not by 25th dismissal.
11 Vadiraj.
Next week, ma'am.
Hmm?
A week time may kindly be granted. A week-
Michael ಮಾತಾಡಿ ಕೇಳಿಸ್ತಾ ಇಲ್ಲ.
a week time may kindly be granted,
Okay.
my lord. Yes, my
Counsel
lord.
for the
And we
petitioner.
have received the certified copy, so we will also file. Fourth objection.
Dispensation ಬೇಡವಾ?
Yeah, yes, yes, ma'am.
Learned counsel for the petition does not press IA 1 of 24, hence IA 1 of 24 stands dismissed. Counsel for the petitioner seeks for and is granted a week's time to make payment of process fee in respect of unserved respondent. ಕೊಡಿ ಯಾರು KSF
And then, my lords, the trial court posted the matter for hearing on the maintainability. For 2 years, he did not address an argument on maintainability. Then he files an application under Order 22, Rule 5. Now, my lord, the court has allowed that IA. The question is, my lord, when a legatee comes and institutes the suit itself, then, my lord, that he is ought to seek, my lord, a prayer with respect to declaration of his right over the property. Then there has to be a proper issue on that, especially when there is a will. And then, my lords, the court can proceed with it. Now,
come on record as a legal representative by
Yes.
way of being a legatee.
Provided-
You are disputing it. Inquiry under 22 Rule 5 has to happen.
yes, my lord. Provided, my lord, if
All
he,
these contentions you can take during the inquiry.
my lord, there is a, my lord, I am seeking the appreciation of this court, a thin line of difference between Order 22, Rule 5 and, my lord, he is seeking a declaration on the will and framing a specific issue in the FDP itself.
Why should that be? If he is a legatee, when he has to establish himself as a legatee, he will have to establish the will.
Certainly. And then, my lord, he has to seek a prayer in the proceedings that be, my lord, that he be declared as so and so, my lords. On the contrary, what he does is, he doesn't do that.
Not required to be declared. If he is declared as a legatee, There's no further declaration of his entitlement to it.
But my lord, under order 22 rule 5, there can't be a declaration with respect to his right to the property.
The testator had a right.
Please, my lord.
Testator had a right.
Testator
The one
had
who issued, who executed the will had a right.
died after the passing of the
He had a
preliminary
right in the
decree.
property. He or she had a right in the property.
Yes,
That is not in dispute.
that is also in challenge and appeal.
That, then you
Yes, my
challenge
lord,
it.
that
That
is
will be
there.
there. You
But-
can't have a double challenge on it.
No, my lord, my point for consideration would be this, my lord. If a proper issue is framed and my lord, if that is a trial is taken on that, then there will be a full-fledged trial on that. Under order 2025, my lord, even in Jaladi Sugna, the apex court holds, it is only to the limited extent of the legal representativeness,
Sure.
but he will not get a right over the property.
Petitioner is before this court seeking for the following reliefs.
No.
Petitioner is aggrieved by the order dated 29/11/24, passed on IA number 5 of 24 in FDP number 12 of 2018 by the senior civil judge and CJM Koppal. By way of the said impugned order, a direction had been issued by allowing the said application filed under order 22 rule 5, an inquiry is being conducted as regards the claim of the petitioner in FDP number 12 of 2018 to be a legatee of the decree holder. The contention of learned counsel for the petitioner is that such an application could not have been allowed without a prayer being sought for by the petitioner, that the petitioner would be entitled, would be to be declared to be entitled to the decree, the proceeds of the decree. In
And
the
also,
present case-
and also an issue to that effect.
And on which basis an issue is to be framed and a detailed trial to be conducted. Having heard learned counsel for the petitioner and having perused the papers, there is no dispute about the decree holder. Though there is a dispute as regards the entitlement of the decree holder, the same is pending in an appeal. Insofar as the apparently there is no stay of the FDP proceedings in the said appeal. The petitioner in the FDP number 12 of 2018 is claiming as a legatee of the decree holder. Once, in furtherance of which, once an inquiry is held, if held, and is able to establish that he is a legatee and thereby a legal representative of the decree holder, the said petitioner would step into the shoes of the decree holder and can proceed therewith. So long as the entitlement of the decree holder is not set aside, the legatee stepping into the shoes of the decree holder, there would be no requirement, in my considered opinion, there would be no requirement to further seek for a declaration that the petitioner stroke legatee is entitled to the fruits of the decree. In that view of the matter, no fault can be found with the impugned order dated 29/11/2024. Impugned order, the petition stands dismissed.
Lord, in that event, the trial could be directed to frame an issue on that will, my lords.
There is an inquiry. Inquiry, all the inquiry will happen as regards the legatee.
No, my lords, under order 22, that's what, I'm sorry, my lord, matter is disposed of. I should not be. But as the Supreme Court says in Jaladi Suguna, my lords, it is only for a limited purpose, my lords. That will not confirm him any right, my lord, as a legatee.
Once he is a legal representative as a legatee, it will confirm.
No, my lord. Kindly, my lord, sir.
You can raise all questions as regards the will executed is left open to be tried, to be considered during the inquiry.
Please.
Yes.
13, Sabil Ahmed.
I appear for the petitioner in this case, my lordships.
Court fee.
Court fees paid, my lordships. Court
Paid.
fees paid.
Rare to be clear. Counsel for the petitioner submit that court fee has been paid.
Lordships, the petitioners are the successful decree holders in OS number 117 of 2012. And their decree is also decree for declaration and permanent injunction is also confirmed in RA, my lordships. In RA 45 of 17. Thereafter, they filed an application for mutation of their name in the RTC.
Relief is to enter your name in 378/1, which is illegally subdivided.
I'll just,
If it is illegally subdivided, first you have to question that.
I'll submit my lordship. My application for mutation was filed in the year 2019. My application was kept in abeyance. The defeated defendants who lost their declaration suit as well as the appeal preferred by them, they filed an application subsequent to my application. Their application is honored. Survey number 378, 1 acre is divided into 4 parts. And thereafter mutation is affected in their names. After this action, again I filed representation at annexure E. Even that is kept in abeyance. My first
You
application.
not made them parties.
Because I had sought only for mandamus. I'll add them as parties.
When they are in their application, they mention the RSA number also. They have to make them parties. In page 180, Your Lordship, they have mentioned the RSA number.
Please see your prayer and consider it's not maintainable.
Please, my lords.
Counsel for the petitioner seeks fund is granted.
Week's time, my lords.
Week's time to bring on record the persons in whose name the RTCs of the subject property stands. Relist on 22nd January.
Much obliged, my lords.
Santosh Malik Bhatt.
Lordship, the amendment is carried out, my lord. The amended cost title will be filed during the course.
This is the matter where, my lord,
Jari.
TMC, elections to the TMC, Lord, they have challenged the notification. Lord, in fact, my lord,
Matter
on the last
pertains to, my
occasion,
lord,
your lordships, my lord,
Annigiri Town Municipal Council, my lord.
Yes.
Yes. Matter pertains
Go
to,
to the apex court.
yes.
I'll, relying upon certain judgments, your lordship, permit me to. Some facts may I state, my lord, because.
Yes.
Your lordship, the first round of rotation, my lord, was challenged and it went up to Supreme Court. In the Supreme Court, my lord, the state filed an affidavit and issued a revised notification. Revised notification is at annexure. The Supreme Court's order is also produced, annexure 14.
Yes.
Page 14. But state filed a detailed affidavit stating that they will revise the original rotation list and issue a fresh notification. According to this affidavit, madam, fresh notification is issued C1, annexure C1. Page 23 is relevant.
Page 22.
23, your lordship.
23, yes.
Lordship should find seal number 5. That is the Annigiri Town Municipal Council, my lord. Now the issue is with respect to president post.
Yes.
It is reserved for ST women. Now, on the same day, my lord, another notification was also issued, page 28, stating that, my lord, at any given point of time, this ratio has to be maintained.
Yes.
This regarding SC women and all. This notification, my lord, according to this notification, the Annigiri Town Municipal President post is reserved for ST women.
Yes.
Now the ST in the annexure D, my lord, page 30 is the list of members, wherein the candidate belonging to ST woman is not there. In the town municipal.
No candidate.
Yes. Candidate belonging to ST woman is not there.
Yes.
But I belong to, my lord, SC women. I don't belong to SC women, my lord.
Yes.
The respondent councillor, he belongs to SC men.
ST.
ST. ST. Now the, my lord, thereafter annexure E, page 32. Deputy Commissioner issues communication stating that since last 1974, may I read last 4 lines?
Yes.
ಉಲ್ಲೇಖ 4ರಲ್ಲಿ ಅಣ್ಣಿಗೇರಿ ಪುರಸಭೆ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮಹಿಳೆ ಸದಸ್ಯರು ಇರುವುದಿಲ್ಲ. ಅಧ್ಯಕ್ಷ ಸ್ಥಾನದ ಮೀಸಲಾತಿಯಲ್ಲಿ 1974ರಿಂದ ಇಲ್ಲಿವರೆಗೂ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಅವಕಾಶ ದೊರೆತಿರುವುದಿಲ್ಲ. ಕಾರಣ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಪುರುಷ ಮೀಸಲಾತಿಯನ್ನು ನೀಡುವಂತೆ ವಿನಂತಿಸುತ್ತಾರೆ. After this communication, my lord, the Deputy Commissioner impugned
yes.
order. Page 33, annexure F. Lord, this is issued, wherein the notification which was issued by the Secretary pursuant to this Supreme Court directions was altered, and, my lord, the post was de-reserved. The post, what as per the notification which was reserved for ST women, is now de-reserved and they are permitting, my lord, ST men to contest the election. This issue has come up.
It's changed from STW to ST.
ST. Yes. This issue, my lord, came up before this. Barala. This issue came up before this honorable court as well as Supreme Court as respect to judgments. This issue was dealt by this court. Whether such de-reservation in the absence of any statutory powers is permissible or not.
Yes. So then we won't hold election at all.
No, it's not like that, my lord. It has to be.
It cannot be changed, and it cannot be changed in your favor also.
Not in my favor. Not in my favor. Then I will take your lordships through the judgment. What the judgment has been. The first judgment is, my lord, this is where election was conducted, and this honorable court, my lord, relevant portion is at para 9, my lord, referring to the Supreme Court's judgment. Para 9.
Yes.
May I read, my lord?
Read.
Srimati Raniamma is elected for the constituency reserved for the scheduled castes, women, whereas the post of Adhyaksha has been reserved for scheduled castes, and it shall be filled up only from the among the persons elected from the constituency reserved for scheduled castes. Section 177 subclause 2C of the Act and the rules specifically provide for the reservation of the post of Adhyaksha and Upadhyaksha for women in respect of each categories. Hence, I do not find any substance in the contention raised by the respondents that the Act and rules do not provide for a reservation of women in each of the categories. In view of the law laid down by the Supreme Court, Srimati Raniamma being elected for the constituency reserved for scheduled caste women is not eligible to contest for the post of reserved for scheduled castes. Therefore, the acceptance of the nomination of the Raniamma to the post of Adhyaksha and declaring her elected as Adhyaksha of Shimoga is illegal, and proceeds to hold that election is the election itself is illegal. In fact, your lordship, similar issue was also arising before the state of in the Maharashtra. There they have brought up a change in the law, my lord. But in the Karnataka Act, my lord, section 42, there is no change. This can be appreciated in
Really, hence I do not find any substance in the contention raised by the respondent that the Act and rules do not provide for reservation for women in each of the categories.
each of the categories.
There is a different issue.
No. This issue was, my lord, the post was reserved for, my lord, the post of presidency was reserved for scheduled castes.
Women and
scheduled caste was there generally. There was no subcategorization whether it was men or women. Scheduled caste was there. Now, scheduled caste woman filed a nomination and she contested and she won.
Yes.
And that election was challenged before the court. This court held, since the post is reserved for scheduled castes and the elected president is from not from that category, she is elected from SC women, she cannot contest election, and therefore the election para 16, my lord, the election itself is held to be illegal. This, my lord, identical issue arose before the Bombay High Court also. Whether in the scheduled caste or scheduled tribe, if there is no subcategorization for men and women,
yes,
what has to be done? Bombay High Court, my lord, it has dealt with that. Next judgment, my lord. Suresh, next judgment. Suresh Pogal. Here also the same issue was arising, my lord.
Para?
Yes, sir. Para 9, my lord. Para 9, it was on a plain reading of proviso, it would reveal that the case of the petitioner is not covered. Yes. It starts from, my lord, para 8, actually, it starts from para 8. We have carefully considered the contentions canvassed by the learned counsel for the parties. In order to appreciate the rival contentions, it is necessary to reproduce the relevant portion of section 30 of the Act, lord, identical provision in the Maharashtra Act. Every panchayat shall be presided over by a sarpanch who shall be elected from the elected members thereof. It is not disputed that the election to the post of sarpanch of Gram Panchayat is exclusively reserved for women general category. It is true that every panchayat is supposed to be presided by sarpanch who gets himself elected by and from amongst the elected members thereof. In the present case, petitioner contested the election for the post of Sarpanch as well as Upa Sarpanch, and he has already been elected as Upa Sarpanch. It is a fact that he is officiating as Sarpanch in the same Gram Panchayat. Therefore, it is clear that till a woman candidate from the general category is available, the petitioner being Upa Sarpanch is looking after the duties of Sarpanch. In such a situation, it cannot be said that the Sarpanch reserved for women general category cannot be kept vacant till woman candidate from the general category to be elected for the post of Sarpanch is available. In such circumstances, we do not find force in the first contention of learned counsel of petitioner, and the same is rejected. The bone of contention of learned counsel for petitioner is that, as per the second proviso to Rule 4A, if the office of Sarpanch is reserved originally for women belonging to backward class of citizens, then the office of Sarpanch for the same tenure can be de-reserved for the Sarpanch can be allowed to backward class of citizens, including male and member. On this analogy, learned counsel for petitioner contend that in the present case, the office of Sarpanch is reserved for women from general category and no candidate is available for women of general category to be appointed to the office of Sarpanch. Therefore, petitioner can be allowed to contest the election for the post of Sarpanch, and his nomination form ought to have been accepted. There is no other contesting candidate available either from the general category or from the reserved category. The contention of learned counsel petitioner is devoid of any merits. In this context, it is necessary to reproduce 4 and 4A of the rules. Rules is provided, my lord, and ultimately, my lord, it was court held that it cannot be de-reserved unless there is a sub-classification in the very category. It cannot be de-reserved. Thereafter, they brought in a change, my lord.
Question of these rules, that notification itself is sufficient. No.
We are of the considered view that the impugned orders passed by respondent directing to keep the post of the Sarpanch vacant.
Yes.
For the tenure for which it is reserved for women from general
Yes.
category is perfectly legal and valid.
Yes. That was
Keep it vacant.
Yes.
No election at all.
One next one submission. This, my lord, this issue.
Only persuasive.
Yes.
Yes.
My lord, this after this judgment, my lord, they brought in an amendment to the rules, and this next judgment, my lord, same issue again arose. This goes against me, my lord. I am citing this because, my lord, the Maharashtra High Court, the Maharashtra State of Maharashtra brought in an amendment to the effect that if
yes,
that if the, my lord, in the category, if there is a sub-classification, they brought in an amendment stating that if SC women, if the post is reserved for SC women and woman candidate is not available, general SC men can be allowed on the amendment. Amendment on this Bombay High Court held that after the amendment it is not permissible. Yes, if the SC woman is not available, SC man can be done. It can be de-reserved for SC women only after amendment. Now, if your lordships kindly peruse section 40 of the Karnataka Act, there is no such amendment.
Act.
Idu Karnataka Municipalities Act section 40, my lord. Before amendment and after amendment is. But such corresponding amendment is not available either in the, my lord, rules, election rules, Karnataka President and Vice President election rules also there is no such rule.
Section 40 of the Municipalities Act.
Yes, my lord, 42 of the Karnataka Municipalities Act 64. Subclause 2A is relevant.
Subclause
2A, your lordship.
Yes.
Yes, 2A only provides, my lord, essentially 2A provides that out of the entire this thing, schedule caste and schedule time can be reserved, subclause A, and 2 clause B says for the president and vice president, backward class can be reserved, and the proviso says if there is no candidate from SC or ST, backward class has to be prioritized. That is the only provision. But it does not say in the act, my lord, it does not say when there is sub-classification in the category, either ST, SC or backward class.
Yes.
This act does not provide in the event where the category is reserved and subdivided into men and women. If there is no men or if there is no woman, what has to be done? Another, this act is very silent.
Annanta category na illa.
Yes. So
The
that,
woman category.
yes. So under that circumstance, what has to be done? This is an anomaly. My lord, similar circumstances I just referred to the Bombay High Court judgment. Before amendment, the Honorable High Court held it cannot be done. State brought in an amendment. After amendment, the same issue again arose before the Bombay High Court. It held after amendment it is permissible, it is permissible. It can be de-reserved for if there is no candidate of woman.
It should be kept
yes
vacant.
Yes, not vacant, my lord. They can clarify.
Well, that is
Yes,
what
that
the-
is vacant. Yes.
That is what the Bombay High Court has
Yes.
said. It should be kept vacant during the tenure.
My lord, this Tahsildar, my lord, acts as a in charge.
Lord, in view of the
And one last submission, my lord. They have referred to the judgment, my lord, earlier when the ST candidate was not, a woman was not there. The present respondent approached this honorable court stating that since there is no candidate available for ST woman, the conducting election for ST woman does not arise. Therefore, it has to be reconsidered. And the approach. This honorable court rightly allowed the writ petition, stating that you have to reconsider. This honorable court did not give any direction, stating that you have to reserve this post for ST women only. ST men. We have to allow the ST men to contest election. This honorable court issued only direction to the effect that it has to be reconsidered in view of the affidavit.
Yes.
Lord, in view of the earlier decision taken by this honorable court by quashing the notification wherein, my lord, ST women, which was reserved, since there was no candidate.
Where is that order?
Yesterday, day before yesterday, that is, which is
What is the order copy?
WP 1051110. Taking note of that, my lord, the lordship was pleased to pass an order.
But Bombay judgment is a little different.
My lord, but para 3, my lord, in that para 3.
Can the deputy commissioner do this?
Yes, my lord. That is.
Can the deputy commissioner issue Annexure F?
Yes, ma'am. Pursuant to the direction issued by the state, where an order has been passed by the state.
Where is the government order?
My lord, may I pass on government order?
Government order. Early file the gate.
So now in persons of this, there should be a change in the number
Yes.
of the total ST president. That you have done?
That whether the corporation has done or not, the TMC has to verify pursuant to the order having been passed.
Because the entire process would have to be redone.
Yes. Yes. Entire.
Somewhere else, somebody ST woman has to come.
Yes.
Creates a ripple effect, my lord.
Whether that has been done by the corporation or that has to be ascertained and mixed.
And you'll have to say, because this is a standalone order cannot be there. It has to be for the entire
Yes.
district.
Yes. Lord, one submission, even if that government order is not applicable to the present case on hand also. Now, in view of the interim order granted by this court, the entire election process has been stalled, even to the vice president also. Now, there is no candidate, either the petitioner or the respondent herein may
And
not.
we'll
be
make it clear that vice president can go on.
Yes.
Now, the
That
entire
is, there is no dispute.
Yes.
But as regards the president, what to do?
Lord, further,
You will have to place what you have done for the entire
even
district.
though, my lord, the judgment which with regarding to the Maharashtra High Court pursuant to the amendment, wherein, my lord, the amendment was brought, if there is no such candidate insofar as ST women, then it has to be treated as ST men. That has been the amendment which was brought. But even if that is taken into consideration, my lord, the government order which has been issued by the state now the government order states that it has to be treated as ST men.
Government order cannot be treated as an amendment to the act.
It is not an amendment to the
It has to be
entire. It is a government order which has been passed.
There cannot be one amendment to
That
the
cannot-
notification.
yes, that cannot- Entire thing has
So
to be.
this,
Yes.
for that district, it has to be a complete notification.
Yes, yes.
Here, deputy commissioner has issued it.
Pursuant to
Pursuant
the.
to the undersecretary's order.
Yes,
But that's not a notification.
yes. That is not on the notification pursuant to the order.
You'll have to issue a proper notification.
Yes, yes.
If you
Insofar
issue
as,
that notification, then nothing will survive.
Yes. Let the direction be.
That
Let
can
them
be-
redo the entire exercise.
only insofar as president post, that can be done.
Hmm?
Not with regarding to the entire, redo the entire process, my lord.
For the district.
For that particular Annigeri, TMC.
Annigeriಗೆ ಹೆಂಗಾಗತ್ತೆ?
ಅಲ್ಲ, only insofar as
Annigeri is ತಾಲೂಕು
ಅಧ್ಯಕ್ಷ ಸ್ಥಾನದಷ್ಟು ಬಿಟ್ಟು ಉಳಿದಿದ್ದನ್ನ
ನೀವು
ನಾವು-
ಇಲ್ಲಿ ಒಂದು ST ಮಾಡಿದ್ರೆ, somewhere ST,
Other
women
talukas
has to be given. And one ST has to be reduced.
Yes.
ಅಲ್ಲ, insofar as ಅಧ್ಯಕ್ಷ post is concerned.
Huh.
Only for others.
Insofar as vice president is concerned, my
Vice
lord.
president will permit you to go ahead.
Yes.
But for the president is concerned, for the district wise, state alla, district wise, you will have to do the notification where the change has to happen. But that may give rise to another set of writ petitions. If elections have already been held.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ
No, elections
elections
are-
I think
ಆಗಿಲ್ಲ.
already.
ಆಗಿಲ್ವಾ?
ಆಗಿಲ್ಲ.
And ಮಾಡಿ ಬೇಗ. The interim order. Dated
3112.
31/12/24
Yes.
stands modified. The respondents are permitted to go ahead with the election for the vice president. Or it's made clear that the elections for the president shall not go on.
Yes.
Learned AGA seeks for and is granted 10 days time to make a submission as to whether whether in pursuance of what steps have been taken, if any steps have been taken in pursuance of the order dated 26 September 24 in WP number 105001 of 2024 for redoing the reservation in respect of Yao district?
Annigeri Taluk.
Dharwad
Dharwad
district.
Dharwad district. Released on 24th
Please,
January.
please.
Please. Highly obliged. Interim order may be extended.
Interim order modify
Please.
ಮಾಡಿದೀವಲ್ಲಪ್ಪ.
My apologies.
15, Girish Bhatt.
Please, my lord.
Case numbers 52, Mr. Adrami.
Council method Melos at page number 126.
ಕೆಳಗಡೆಗೆ ಬಾಟಮ್ ಲೈನ್ಸ್ ಜೆರಾಕ್ಸ್ ಆಗಿಲ್ಲ ಅಂತ ಬಟ್ ರಿಲೆವೆಂಟ್ ಪೋರ್ಷನ್ಸ್ ಹ್ಯಾವ್ ಬೀನ್ ಜೆರಾಕ್ಸ್ ಕರೆಕ್ಟ್ಲಿ.
Relevant ನೀವು ಡಿಸೈಡ್ ಮಾಡ್ತಿರೋ
125 and 126. ಬಾಟಮ್ ಲೈನ್
ಯಾವುದು ಇಲ್ಲ 127 to 131 ಲಾಸ್ಟ್ ಎಷ್ಟು ಲೈನ್ ಹೋಗಿದೆಯೋ ಗೊತ್ತಾಗಲ್ಲ ಇದ್ರಲ್ಲಿ.
126, 128.
What is this?
These are the election rules.
Rules, so we can always refer to the rules.
Yes.
ಕರ್ನಾಟಕ ಪಂಚಾಯತಿ ರಾಜ್ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷರು ಚುನಾವಣೆ ನಿಯಮಗಳು ಕೊಡಿ. Annexure K are the rules as regards which the office objection has been raised. This court can always refer to rules available with the court. Hence, office objection on Annexure K is overruled. Yes.
My lord, the petitioner challenged the impugned judgment. Final order passed in election petition number 1 of 2023, declaring the election process conducted to the post of Adhyaksha and Upadhyaksha void by Annexure Z. And my lord, the relevant portion is at page 117 and 118. The learned judge of the designated court orders state election commission to conduct the election of Adhyaksha and Upadhyaksha, which is totally contrary to the act and the rules under Karnataka Panchayat Raj Act.
Respond number 1, stroke Karnataka State Election Commission. Deputy Commissioner, please stroke Karnataka State Election Commission. Deputy Commissioner is there in that order.
Is the authorized officer to issue notification in respect of conducting election
And
procedure?
he is going to appoint the returning
Please,
officer.
please, my lord.
Election Commission has no role.
Yes, and
If that word is removed, of the Karnataka State Election Commission, Bangalore, adu hodre, respondent number 1 is there alva?
Lord, respondent number 1 is the
Deputy Commissioner.
ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಒನ್
ಹಾ.
ಅಂತ ಹೇಳಿ ಅದರಲ್ಲಿ
election petition ಅಲ್ಲಿ.
ಡಿಸಿ ಉಳಿತಾರಲ್ಲ ಅಂತ
Yes.
ಹೇಳಿ
Oh.
ಈಗ ಯಾರು ಕಂಡಕ್ಟ್ ಮಾಡ್ಬೇಕಾಗಿರೋದು ಎಲೆಕ್ಷನ್?
Deputy Commissioner. One, the gist of the matter, my lord, on 23/7/2023, elections were conducted at the post of Adhyaksha and Upadhyaksha. So respondent number 2 was appointed as the returning officer,
Yes.
CDPO. He conducts the election. He explains the procedure. For a minute, I wish to take your lordships to the rule.
I mean, your only contention is the State Election Commission cannot conduct this election.
Not only that, my lord.
Is not the concerned authority.
Yes.
But the order is respondent number 1 stroke
Please.
Karnataka State Election Commission.
Yes.
Respondent number 1 is the Deputy Commissioner.
Deputy Commissioner.
But Deputy Commissioner
Please.
will do it.
No, no, besides that, the very validity of the judgment is challenged on several other grounds, my lord, because for a,
ಹೇಳ್ತಾ ಇರೋದು ಒಂದೇ ground.
illa, that is, for a minute, I want to take your lordships to page 126 for a minute.
126 we can't refer to your.
Yes.
ಇದು ಕೊಡಿ ಅದು. Rules. Election rules. Adhyaksha. Is rule number?
Rule number 8, sub rule 9.
No confidence ಅಲ್ಲಪ್ಪ election.
ನಾನು ಹಾಕಿದ್ರಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿದೆ.
ಹಾಕಿರೋದ್ರಲ್ಲಿ ಕ್ಲಿಯರ್ ಇಲ್ಲ.
Please.
ಅದೇ ಆಫೀಸ್ objection.
Please. 1995 rules. Election of Adhyaksha and Upadhyaksha.
ಇದು ಅಲ್ಲಿ ಇಸ್ಕೊಳ್ಳಿ ಅವ್ರ. Sub rule 9 of rule 8.
Rule 8, sub rule 9, my lord.
There is no sub rule 9 of rule 8. Like 94 rules.
95 ಇದ್ದು. ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ ನೋಡಿ ಗೊತ್ತಾಗುತ್ತೆ.
ಎಲ್ಲ ಅದೇ ಅದು ಕನ್ನಡ ಇಂಗ್ಲಿಷ್ 95.
Yes, rule
ಕನ್ನಡದಲ್ಲಿ
rule 8 sub rule 9. ಹೇಳಿ.
Yes. ಮತಪತ್ರವನ್ನು ಸ್ವೀಕರಿಸಿದ ಮೇಲೆ ಸದಸ್ಯನು ಮತಪೆಟ್ಟಿಗೆಯ ಸ್ಥಳಕ್ಕೆ ಹೋಗಿ ಮತ್ತು ಅವನು ಯಾರಿಗೆ ಮತ ಇಚ್ಛಿಸಾನೋ ಅಂತ ಅಭ್ಯರ್ಥಿ ಹೆಸರು ಮುಂದೆ ಎಕ್ಸ್ ಮಾಡಿ ಮತ ನೀಡುವುದ ಗುರುತು ಕಾಣುವಂತ ಮತಪತ್ರವನ್ನು ಮಾಡಿಸಿ ಸಭೆ ಉದ್ದೇಶಿಸಿದ ಮತಪತ್ರ ಹಾಕತಕ್ಕದ್ದು. ಮತದಾರರು ಮತಪತ್ರಕ್ಕೆ ಸಹಿ ಮಾಡತಕ್ಕದ್ದಲ್ಲ ಮತ್ತು ಆತನ ಗುರುತನ್ನು ತಿಳಿಯಬಹುದಾದಂತೆ ಯಾವುದೇ ಇತರ ಗುರುತು ಮಾಡತಕ್ಕದ್ದಲ್ಲ. ಹಾಗೆ ಸಹಿ ಮಾಡಿದ ಗುರುತು ಮಾಡಿದ ಅಥವಾ ಒಬ್ಬ ಹೆಚ್ಚಿಗೆ ಹೆಸರನ್ನು ಗುರುತಿಸಿದ ಅಂತ ಮತಗಳು ಅಸಿಂಧವಾಗತಕ್ಕದ್ದು. Now I take your lordships to the proceedings at annexure A. So it is only by marking X and X only against the name of the candidate to whom he wants to vote.
Yes.
Now the minutes of the election recorded at annexure A, my lord. Page starts from page 24.
Yes.
The relevant page, my lord, is 27. ಹುಡೇಮ್ ಗ್ರಾಮ ಪಂಚಾಯಿತಿ ಅಧ್ಯಕ್ಷರ ಸ್ಥಾನಕ್ಕೆ ಚೋಳುಪಾಲಯ್ಯ ಹಾಗೂ ರಾಮಚಂದ್ರಪ್ಪ ಬಿ ಎಂಬರು ಅಧ್ಯಕ್ಷ ಚುನಾವಣೆಯಲ್ಲಿರುವುದರಿಂದ ಚುನಾವಣೆ ಅವಶ್ಯವಿರುವುದರಿಂದ ಕರ್ನಾಟಕ ಪಂಚಾಯತ್ ರಾಜ್ ಅಧ್ಯಕ್ಷರ ಮತ್ತು ಚುನಾವಣೆಗಳ 95(8) ಅನ್ವಯ ಚುನಾವಣೆ ನಡೆಸಿತು. ಸದರಿ ಚುನಾವಣೆಯಲ್ಲಿ ಎಲ್ಲ ಸದಸ್ಯರು ಮತಪತ್ರಗಳನ್ನು ಚಲಾಯಿಸಿದರು. 19 ಸದಸ್ಯರಲ್ಲಿ ಶ್ರೀ ಚೋಳುಪಾಲಯ್ಯ ಇವರಿಗೆ 6 ಮತಗಳು ಬಂದಿದ್ದು, ರಾಮಚಂದ್ರಪ್ಪ ಇವರಿಗೆ 7 ಮತಗಳು ಬಂದಿರುತ್ತವೆ ಮತ್ತು 6 ಮತಗಳು ಅಸಿಂಧುವಾಗುತ್ತೆ. ಸದರಿ ಅಧ್ಯಕ್ಷರ ಚುನಾವಣೆಯಲ್ಲಿ 7 ಮತಗಳನ್ನು ಪಡೆದು ಸಿ ರಾಮಚಂದ್ರಪ್ಪ ಇವರು ವಿಜೇತರಾಗಿರುತ್ತಾರೆ. So this is the petitioner has received majority of valid votes, and 6 votes were rejected out of 19 votes. So declares. This was challenged before the designated court, my lord, wherein
Yes.
the act and the rules provide that the designated court shall declare.
Yes.
For a minute, I wish to take your lordships to rule 19, sorry, rule 17, my lord.
Yes.
Start from 15. The process of the learned designated judge of the hearing. ತಾನು ಸೂಕ್ತವೆಂದು ರೂಲ್ 15 ತಾನು ಸೂಕ್ತವೆಂದು ಭಾವಿಸಿದ ವಿಚಾರಣೆ ತರುವಾಯ ಮತ್ತು ವಿವರಣೆಯ ಪಕ್ಷಗಾರರಿಗೆ ಅಹವಾಲು ಹೇಳಿಕೊಳ್ಳುವ ಅವಕಾಶ ನೀಡಿರುವಾಯ ಅರ್ಜಿಯನ್ನು ವಜಾ ಮಾಡುವ ಅಥವಾ ಅಭ್ಯರ್ಥಿಯ ಚುನಾವಣೆಯು ಶೂನ್ಯವೆಂದು ಘೋಷಿಸುವ ಅಥವಾ ಚುನಾಯಿತ ಅಭ್ಯರ್ಥಿಯ ಚುನಾವಣೆಯು ಶೂನ್ಯವಾಗಿರುವುದಾಗಿ ಮತ್ತು ಅರ್ಜಿದಾರ ಅಥವಾ ಇತರ ಯಾವ ಅಭ್ಯರ್ಥಿ ಕ್ರಮಬದ್ಧವಾಗಿ ಆಯ್ಕೆಯನ್ನು ಘೋಷಿಸುವ ಆದೇಶವನ್ನು ಮಾಡಬಹುದು and nothing beyond this. And there is absolutely no provision provided either in the act or in the rules to hold to issue directions to hold a fresh election to the post of Adhyaksha or Upadhyaksha. 3 things stipulated, my lord: either to dismiss the petition or to declare the election of a particular candidate is void, and the prayer, my lord, that a particular man who challenges to declare his election is void.
So it's been declared as void, so you don't want election.
Yeah, he has ordered for holding fresh elections.
He has also declared the election of the petitioner as void.
The entire process is void anta ಹೇಳಿದರು. That is not permissible.
Election is void anta declare ಆಗಿದೆ.
ನನ್ನ ಎಲೆಕ್ಷನ್ void ಅಂತ ಹೇಳಿದ್ರೆ ಅವನ್ ಪಿಟಿಷನ್ ಹಾಕಿದ ಎಲೆಕ್ಷನ್ ಅವನ್ ವ್ಯಾಲಿಡ್ ಅಂತ ಹೇಳಿ ಡಿಕ್ಲೇರ್ ಮಾಡಬೇಕು. ಮಾಡಿಲ್ಲ.
ಮಾಡೋದು ಬೇಕಾಗಿಲ್ಲ.
ಮಾಡಲಿಲ್ಲ ಅವರು.
ಮಾಡಬಹುದು. That is ಅಥವಾ
for a minute. I take your lordship to section 20 for a minute of the act.
Yes.
Yes.
Section 20.
20 of the Gram Panchayat Raj Act, my lord.
Yes.
Grounds on which a candidate other than the written candidate may be declared to have been elected. If any person who has filed an election petition has, in addition to calling in question the election of written candidate, claims a declaration that he himself or any other candidate has been duly elected, and the designated court is of the opinion that in fact the petitioner of such other candidate received a majority of valid votes, that but for the votes obtained by the written candidate by corrupt practices, the petitioner of such other candidate would have obtained a majority of the valid votes, the designated court shall, after declaring the election of a written candidate to be void, declare the petitioner or such other candidate as the case may be to have been duly elected.
Prayer, which is, where is the petition? Election petition.
Election petition.
My lord, election petition is at Annex B, my lord.
What is the prayer sought for?
Page 34.
Yes.
ಆದ್ದರಿಂದ lordship page 34.
34 para 9.
Yes. ಆದ್ದರಿಂದ ಸದರಿ ದಿನಾಂಕ 27/7/23 ನಡೆದ ಸದರಿ ಹುಡೇಮ್ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷ ಚುನಾವಣೆ ಅನೂರ್ಜಿತವೆಂದು ಘೋಷಿಸಬೇಕೆಂದು ಮತಗಳ ಮರುವಣಿಕೆ ಮಾಡಿ ಅರ್ಜಿದಾರರು ಸದರಿ ಹುಡೇಮ್ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷ ಘೋಷಿಸಬೇಕೆಂದು ಈ ಮೂಲಕ ಪ್ರಾರ್ಥಿಸಿಕೊಳ್ಳುತ್ತಾರೆ. This is not permissible. Either he should have sought the my election to be void to declare him as a written candidate. That has not been sought. One more interesting aspect, my lord. The petition is filed under section 15 of the act.
That is section 20. Now
Please.
you come to
one more important aspect I want to take your lordships before
15 ge bani.
15 pertains only in respect of the election to the election of members of Gram Panchayat. In fact, the procedure is governed by section 45(2) for a minute, my lord. I want to take your lordships first to
For the president, alva.
how 45.
Yes.
Yes. Procedure for election of Adhyaksha and Upadhyaksha on the establishment of Gram Panchayat, so and so. Subsection 2. Any dispute relating to the validity of the election of Adhyaksha or Upadhyaksha of Gram Panchayat under this act shall be decided by the designated court, having jurisdiction over the panchayat area or the major portion of panchayat area, whose decision there shall be final. So the petition is one ought to have been filed under section 45 subsection 2, whereas he files a petition under section 15. That's one thing, my lord. And my lord, section 20 and rule 17 that I brought to you, lordships, the rules of 1995 pertaining to election Adhyaksha Upadhyaksha, it has only 3 options: either to declare a particular candidate's election is void and to declare a particular candidate is elected. That has not been followed. It is in clear violation of section 20 subsection 2 and rule 17, my lord. There is no provision provides for holding fresh elections in an election dispute. The very prayer itself is contrary to the act and the rules, my lord.
It is his choice whether he wants to be declared. If a person is not even a candidate,
yes,
a member can file it.
Correct, my lord.
So can a member ask for him to be himself to be declared as a elected representative
that's what,
as Adhyaksha
how?
If he is not even contested?
If he is not contested, the act also provides the candidate who is eligible to declare is to be declared as a winning candidate. That's what, my lord.
If he seeks for, if the petitioner seeks for,
Yes.
petitioner doesn't say, he is not even a candidate.
Idರಲ್ಲಿ candidate ಅವನು.
If he is not a candidate, ನೀವು ಹೇಳ್ತಾ ಇರೋದು ಅದು prayer ಕೇಳಲೇಬೇಕು ಅಂತ. That is not the right to this one. You please see section 18 also.
Please.
Section 18 says or declaring the election of all or any of the returned candidates to be void, or declaring the election of all or any of the returned candidates to be void and the petitioner or any other candidates to have been duly elected. It's or. It's a choice. If they don't seek for that relief, that cannot be granted.
Here,
there is no such relief which has been sought for at para 9.
Here, I'll come to the gist of the matter. Out of 19 votes polled, petitioner got 7 votes. The respondent, contesting respondent received 6 votes. 6 votes were declared valid. Having marked instead of X plus mark, I take your lordships to the evidence of RW 1, page 63. '63, my lord.
Yes.
The procedure adopted starts from page 62. Last paragraph. ಸದರಿ ಲಕೋಟೆಯನ್ನು ಅದರಲ್ಲಿ ಅಧ್ಯಕ್ಷರ ಚುನಾವಣೆಗೆ ಸಂಬಂಧಿಸಿ ಚೊಳ್ಳುಪಾಲಯ್ಯ ಮತ್ತು ರಾಮಚಂದ್ರ ಚುನಾವಣೆಗೆ ಸ್ಪರ್ಧಿಸಿದ್ದು ಸದರಿ ಚುನಾವಣೆಗೆ ಸಂಬಂಧಿಸಿದ ಮತಪತ್ರಗಳನ್ನು ಪರಿಶೀಲಾಗಿ ಚೊಳ್ಳುಪಾಲಯ್ಯ ಹೆಸರಿನ ಕೊಟ್ಟಿದ್ದಾರೆ 6 ಮತಪತ್ರಗಳಿದ್ದು ಚೊಳ್ಳುಪಾಲಯ್ಯ ಹೆಸರಲ್ಲಿ ಎಕ್ಸ್ ಮಾರ್ಕ್ ಪೆನ್ನಿನ ಇಂಕಿನಲ್ಲಿ ಎಂಬುದು ಕಂಡುಬರುತ್ತದೆ. ಸದರಿ ಮತಗಳನ್ನು ನಿಶಾನೆ R1 ರಿಂದ 6 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ರಾಮಚಂದ್ರಪ್ಪನವರ ಹೆಸರಿನಲ್ಲಿ ಒಂದು ಲಕೋಟಿದ್ದು ಅದರಲ್ಲಿ 7 ಮತಪತ್ರಗಳಿದ್ದು ಸದರಿ ರಾಜನ ಹೆಸರಿನಲ್ಲಿ ಎಕ್ಸ್ ಮಾರ್ಕ್ ಪೆನ್ನಿನ ಇಂಕಿನಲ್ಲಿ ಎಂಬುದು ಕಂಡುಬರುತ್ತದೆ. ಸದರಿ ಮತಪತ್ರ ನಿಶಾನೆ R7 ರಿಂದ 13 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಮತ್ತೊಂದು ಲಕೋಟಿದ್ದು ಅದರ ಮೇಲೆ ಅಸಿಂಧು ಮತಪತ್ರ ಎಂಬುದಾಗಿ ನಮೂದಿಸಿಕೊಟ್ಟು 6 ಮತಪತ್ರಗಳಲ್ಲಿ ಒಂದು ಮತಪತ್ರದಲ್ಲಿ ಚೋಳುಪಾಲಯ್ಯ ಮತ್ತು ರಾಮಚಂದ್ರ ಇಬ್ಬರ ಹೆಸರಿನ ಮುಂದೆ ಎಕ್ಸ್ ಮಾರ್ಕ್ ಅನ್ನು ಪೆನ್ನಿಲಿಂಗ್ ನಮೂದಿಸಿಕೊಂಡು ಬರ್ತದೆ. ಸದರಿ ದಾಖಲೆಯನ್ನು ನಿಶಾನೆ R14 ಎಂದು ಗುರುತಿಸಿತು. ಎರಡನೇ ಮತಪತ್ರ ರಾಮಚಂದ್ರ ಹೆಸರಿನ ಮುಂದೆ ಇಂಕ್ ಪೆನ್ನಲ್ಲಿ ಪ್ಲಸ್ ಮಾರ್ಕ್ ಇರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಸದರಿ ದಾಖಲೆ ನಿಶಾನೆ R1 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಅದೇ ರೀತಿ ಮೂರನೇ ಮತಪತ್ರದಲ್ಲಿ ಚೋಳುಪಾಲಯ್ಯರ ಹೆಸರಿನ ಮುಂದೆ ಇಂಕ್ ಪ್ಲಸ್ ಮಾರ್ಕ್ ಇರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಸದರಿ ದಾಖಲೆ ನಿಶಾನೆ 6 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಅದೇ ರೀತಿ ನಾಲ್ಕನೇ ಮತಪತ್ರ ಚೋಳುಪಾಲಯ್ಯ ಹೆಸರಿನ ಮುಂದೆ ಇಂಕ್ ಪೆನ್ನಲ್ಲಿ ಪ್ಲಸ್ ಮಾರ್ಕ್ ಇರುವುದು ಕಂಡು ಬರುತ್ತದೆ. ಸದರಿ ನಿಶಾನೆ R17 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಅದೇ ರೀತಿ ಐದನೇ ಮತಪತ್ರ ಚೋಳುಪಾಲಯ್ಯರ ಹೆಸರಿನ ಮುಂದೆ ಪ್ಲಸ್ ಮಾರ್ಕ್ ಎಂದು ಸದರಿ ದಾಖಲೆ ನಿಶಾನೆ R18 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಅದೇ ರೀತಿ ಆರನೇ ಮತಪತ್ರ ಚೋಳುಪಾಲಯ್ಯರ ಹೆಸರಿನ ಮುಂದೆ ಇಂಕ್ ಪೆನ್ನಲ್ಲಿ ಪ್ಲಸ್ ಮಾರ್ಕ್ ಎಂದು ಸದರಿ ದಾಖಲೆ R ನ್ಯಾಯಾಲಯದಿಂದ 4 DVD ದಾಖಲೆ ಹಾಕಿದ್ರು. ಅವರನ್ನು ಯಾವ ಮೂಲಕ ಅಂತ ನನಗೆ ವೈಯಕ್ತಿಕ ಮಾತಿಲ್ಲ. And my lord, the whole process is by recording the minutes and it is videographed also. So the
plus and X is only a turn of ink paper ಇಟ್ಕೊಂಡು ಹೆಂಗ್ ಮಾಡಿದಾರೋ ಹಂಗೆ ಬರುತ್ತೆ. It's not a different thing. There's no signature or anything.
Yes.
You get the records.
Please.
That could also be X.
That.
The difference is between X
and plus.
There's no other difference. that if plus is taken as X, then the whole issue will arise.
Yes. Please. Records can be secured from the court itself, district court. Yes.
Original ಅಲ್ಲೇ ಇದೆಯಲ್ಲ?
ಅದೇ ಅಲ್ಲೇ ಇರುತ್ತೆ.
Learned AGA accepts notice for respond number 2 and 3. Counsel for the petitioner is permitted to serve the counsel for respond number 1 before the trial court. Registry is directed to secure the records in election petition number 1 of 2023, which is pending on the file of the senior civil judge and JMFC at Kudulgi, forthwith, relist on 20th.
Interim order of statement. Thank you. Please, this is covered by the judgment of this honorable court.
In the meanwhile, respondents are restrained from issuing any fresh election notification.
Please.
16, SS Niranjan.
During the course of the day, I will consider it. During the course of the day.
In serious objection.
Only two of office objection, my lordship. In the name, my lordship, by typographically it is not, and in the marking.
We clarified. 2 and 3. Are they the same?
Yes, my lordship. My lordship, they are not same, but by typographically it is mistakenly cut and paste, my lordship. The name of the petitioner number 3 is the Kavita, my lordship, daughter of. That should be, I will correct it.
Counsel for the petitioner seeks fund is granted a week's time to comply with the office objection. Relist on 20th.
May please.
17, Narayan B. Yazi.
Yes, Mr. Yaji.
20th or 21st, your lordship. 20th or 21st, your lordship may taken.
And AG is and is granted 10 days time to get ready and address this relist. 21st January.
22nd, please.
22nd January.
18, Dattatreya Kulkarni.
Lord, for the petitioners, my lord. The first matter, my lord, I have also filed a memo to withdraw the writ petition so that IA, my lord, may not be of any.
Petition will only go.
But, my lord, there is some opposition from the university council.
You don't want him to withdraw?
No, we don't want that. He should withdraw it because that is to be heard along with the next petition. Because there are some contentions which are beneficial to us. That is
You
why
always
even
produce the
last,
petition.
this court last time, it is ordered that that is to be heard along with this.
Mr. Patil, if he withdraws also, you can rely on the amendments made in the petition.
Yeah, both are same. He files this without withdrawing. Let it be along with that. If it is heard together, what happens? My lord? Why
When he
should-
wants to withdraw it only for relying, how can we stop him from withdrawing?
No, not if you last time.
Order copy, Kodi. It's already been, order has been passed.
Yes.
Yes.
My lord, if there is opposition to that, my lord, it may be heard. My request, my lord, that it could be heard on one particular date, my lord, because
Today
all
is
these
the date.
petitioners are.
Today is the date.
I am ready.
You are ready?
I am ready.
On behalf of the state.
22.
On
All
behalf
are ready,
of,
na?
on behalf of the state, pleadings are not completed.
Not come. You have to file objections.
Learned AG appears. Keshav Reddy. Keshav Reddy
Again,
appears.
important.
Lord, this land was notified for acquisition.
18.1. Shri Harsh Desai has entered appearance for the petitioner. Registry is direct deleted name of Shri Ashok B. Memo of retirement filed by Shri Ashok Patil is accepted. He is permitted to retire from the matter. 18.2, same order. 18.2.
Respondent.
Same order, my lord. I have
As
filed
well-
him.
Same order for
Same
respondent.
order. Relist on
Product. 22nd or 23rd.
22nd.
First week of February. For hearing, first week of February.
At the request of Shri K.L. Patil and council, relist on 4th February.
Okay.
Padmaraj Tatpatri.
I appeal for the respondent.
What is the amendment? Any objection?
Lords, the application is incomplete, Lords. The prayer, in the application, wherein Lords, the petitioner wants to introduce a passing of another order That is not produced along with the application.
Amendment application ಅಲ್ಲಿ IA 1 of 23. For amendment ಇಲ್ಲಿದೆ. Amended WP.
Certain grounds and
Has the amendment application been allowed?
yes, that can be allowed. Only certain grounds.
Amended petition ಹಾಕಿದ್ದಾರೆ.
Allow ಆಗಿಲ್ಲ ಅದು.
Allow ಆಗಿಲ್ವಲ್ಲ?
ಆಗಿಲ್ಲ.
That order, Lords, is not accompanying the application or the writ petition, Lords. The copy is served to me.
It is filed on 28/6/2023.
Yes, we got it.
Thereafter, my lord, it has listed.
What is incomplete, Mr. Bimar Kaur?
In
That
prayer
copy was
A1,
not
my lord.
published to me in the application, Lords.
Not furnished to you.
Please.
Incomplete ಅಂತೀರಾ, not furnished ಅಂತೀರಾ, ಏನ್ ನಿಮ್ submission ಏನು?
Only the application copy is served, Lords. As per the prayer, Lords, it is produced as an issue. It may be allowed, Lords.
Accepting the reasons stated in support of IA 1 of 24, the amendment sought for to bring on record certain additional grounds and additional prayer is allowed. Counsel for the petitioner to carry out necessary amendment and file amended, carry out necessary amendment. The amended petition already filed is taken on record. Counsel, the respective counsels for respondents. ನಿಮ್ notice ಆಗಿಲ್ವಾ?
ಆಗಿದೆ.
PS served ಅಂತಾನೆ ಇದೆ. ಏನಪ್ಪ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಸರಿಯಾಗಿ ಇಲ್ವಲ್ಲ?
1 and 2 accept notice. 1 and 2 accept
And
notice.
AGA accepts notice for
1 and 2.
respond number 1 and 2, registry is direct print his name as such. The respondents are granted 3 weeks time to file their respective statement of objections. Objections 31st, relist on 5th.
Please.
Apply.
20, Prashant F. Gowda.
Lord, I appear for the petitioner. This matter was ordered to be listed yesterday, my lord, and this is the challenge to the order of the land tribunal, wherein the land has already been surrendered by the tenant prior to 1374 under the Bombay Tenants and Agricultural Land Act.
Mr. Bangi, you are
1955.
appearing for
Yes.
Mr. S.H. Yadwad. Who is Mr. S.H. Yadwad?
Yadwad.
Yaar contesting party yaar.
No, I am for the contestant.
Mr. Yadwad is not contesting.
Not sailing with me.
Sailing with?
Sailing with me.
So ಅವ್ರೇನ್ ಬೇಕಾಗಿಲ್ಲ.
Yes.
ನೀವಿದ್ದೀರಾ ಅಂತ ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ.
Yes.
ದೀಪಾ ಪಿ ದೊಡ್ಡಟ್ಟಿ.
Sailing with me.
ಅದಕ್ಕೆ ಬರ್ತಾ ಇಲ್ಲ. Yes. Yes, Mr. Gowda. Go ahead.
I'm not here.
Freeze ಆಗಿದೆ.
Prashant F. Gowda.
Yes.
You are ready ಅಲ್ವಾ?
Yes.
Pass over.
Lord, may I request me, Lord, the government may be direct, secure the records.
ಎಲ್ಲಾರು ಬೇಡ. ಬಂದಿದ್ಯಾ? Take inspection.
Very good.
And AGA submits that the records have been received. Both the councils are permitted to take inspection of the same and get ready to address their arguments. Relist on 23rd January. Order earlier granted is extended till next year.
21, Narayan D.
Recalling, why was it dismissed?
Dismissed for non-prosecution as I could not comply the office objections. I was not keeping well.
Pending consideration of IA 1 of 24, counsel for the petitioner is permitted to comply with the office objection. If office objection is not complied by 30th, IA 1 of 24 will be liable to be dismissed. Relist on 5th February.
Please.
22, Vyas Desai.
Petitioner, my lord, is running a poultry. The land, my lord, is situated in the town panchayat. within the town panchayat has demanded tax
Yes.
from the petitioner, my lord. Under the Municipalities Act, my lord, it has demanded the tax. First, my lord, that the town panchayat cannot exercise powers under Municipalities Act. And the
Manche Town Panchayat.
poultry
Respondent
being
number 4 has to answer, my lord.
Saukar.
Mantri D. Saukar.
Lord, construction being made for the purpose of poultry, my lord, would come within the definition of agriculture, and therefore, my lord, tax cannot be demanded.
They held that in.
This is your lordship's judgment, my lord.
Insofar as under section 199, my lord, your lordship has rendered judgment.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is the petitioner that respondent number 4 has sought to levy and demand tax on a poultry farm being run within the limits of the town panchayat. This aspect has been dealt with by this court in its order dated 5th September 23 in WP number 38871 of 2016. And this court has come to a categorical conclusion that running of a poultry farm is not a commercial activity, and the building used for a poultry farm would not be a commercial building. And further, that it is an agricultural activity. In that view of the matter, I pass the following order. Writ petition is allowed. Certiorari is issued quashing the so-and-so.
But they have not challenged the endorsement here.
It's the information given in the RTI. my lord.
Yen keli, the SAS form and
Not
challenge
challenged the endorsement.
demand challenge madilla.
The form number,
They've given you a form.
please.
Where have you challenged the demand?
Lord,
Moreover, it comes under
inadvertence, my lord.
Municipality Act.
File a amendment application. Is Bardit Counsel
Please.
for the petitioner seeks for and is granted 10 days time to file amendment application. Released on 24th January.
Obliged.
23, Prasad Patil.
For the impleading applicant, my lord.
Let's appear for respondent numbers 2 and 3 in all these matters.
Yesterday's matter, my lord. My lord, yesterday's matter, my lord. My lord, she had filed an application for impleading. That may be allowed.
This filed in which matter?
In 34.10, my lord, in writ petition number 106256 of 2023. Petitioner being
CL
Shankar
number?
Madhav Paushe.
CL number?
23.
23, my lord. Sorry, 23.
In 23 you have filed.
Yes, my lord.
Where is the application?
Point.
23 L.
0.25, my lord. 23.25, my lord.
23.25.
25.
Allah.
25.
There's no 23.25. Yavralapa.
Lord, the writ petition number is WP 106256, my lord.
Where do we search for
Lord,
it?
23.7 ballots. 23.7.
7.
7.
23.7. Madam, you need to know that 23.7, accepting the reasons stated in support of IA 2 of 24. The person named therein is brought on record as respondent number
4, my lord. Proposed respondent number 4, my lord.
Respondent number 4. More so since there's no objection on part of the counsel for the petitioner for respondent number 2 and 3. Counsel for the petitioner to carry out necessary amendment and file amended cost title. Yes.
Please.
Much obliged, my lord.
Lord, the preliminary notification, my lord, is issued on 13/9/2022, my lord. Lord, it is at page number 30, my lord.
Yav petition ತಗೊಳ್ಬೇಕು?
My lord, 23.13.
23.13.
That is 105937 for 2020.
So contesting respondent is NHA.
Please.
Yes, 23.1.
1 minute. That is
937.
Lakshman Ningappa is the petitioner.
Yes.
Lakshman Ningappa, please. Lord, the preliminary notification, my lord, is dated 13.
Michael ಮಾತಾಡ್ಬೇಕು ಅವ್ರು ಕೇಳಿಸ್ಬೇಕು.
Please. Lord, the preliminary notification, my lord, is dated 13/9/2022. My lord, it is at page number 30. If your lordships could kindly take page number 30, my lord. The acquisition, my lord, is required for the building of 4 and 6 lane maintenance, management and operation of Belagavi Eastern and Western bypass. My lord, page 30, please, my lord. At the bottom, my lord.
Yes.
Please.
Yes.
My lord, the project, my lord, is, my lord, for Belagavi Eastern and Western bypass, Belagavi Ring Road. In the stretch of land so and so in the district of Belagavi in the state of Karnataka.
Yes.
This is the project, my lord. If your lordships would kindly come to page 31, my lord. There is one portion, my lord, which is relevant. That is, my lord, above schedule, my lord, if your lordship could see. The land plans and other details of the land to be acquired under their notification are available and can be inspected by the interested person at the aforesaid office of the competent authority.
Yes.
My lord, after that, my lord, if your lordship could kindly see the schedule. My lord, what has been shown in the schedule, my lord, is first is the serial number. Second, my lord, is survey number, plot number, type of land, nature of land, area in local unit, area in hectare. These are the descriptions, my lord, that
No
have been
details of
provided.
the owners has been mentioned.
Sorry, my lord.
No details of the owners has been mentioned.
Please, that is one of our contentions. If your lordships could kindly see, my lord, to this preliminary notification, my lord, we have filed our objections. Annexure D, my lord. Annexure D, my lord, page 38, please, my lord.
Yes.
My lord, para 2 would be relevant, my lord. Your authority has issued notification dated so and so, which is illegal in the eyes of law. As the perusal of the description as per schedule would indicate that the extent of the portion of the survey number that is sought to be acquired is not demarcated. Name of the owners of the property is not mentioned. Boundaries to the extent sought to be acquired is not mentioned. Hence, the description as contemplated under section 3A2 of the National Highway Act so and so is defective, and the said notification is not published as per the provisions of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation, Resettlement Act. And further, it is submitted that the said notification does not mention regarding second schedule of the Act of 2013 regarding rehabilitation and resettlement of landowners would lose the land in the proposed acquisition. My lord, the rest of the portion, my lord, are all details, my lord, where we are saying that there are certain structures and there are fertile lands and
Your first contention is that the details of the property owner and details of the property to be acquired are not mentioned.
Please, my lord.
Second contention is
contention,
that,
my lord, if your lordship
Act of 2013 has not been complied with.
Please. And the next contention is, my lord, if your lordships could kindly come to Annexure E, page 41. To my objections, my lord, they have, my lord, rejected it. My lord, it is a cyclo-styled order, my lord. In fact, I have produced Annexure E, F1, F2, my lord, where the contents are one and the same. What they change is only, my lord, the address of the petitioner and the survey number.
Yes.
They're all one and the same, my lord. The second portion, my lord, the portion of the land along with other adjoining lands are required for construction of Belagavi Ring Road for the use of general public and as well as development of Belagavi city and around the area. The proposed ring road will also reduce the pressure of the transport and smoothing travel. Hence, your request is not considered. And
yes,
Lord, so our contention is that, my lord,
all
there
of
is
them it is the same
non-application.
thing.
All of them is the same.
Judgments ಕೊಡಿ ಎರಡು ನಮ್ದೇ ಇದಾವೆ.
Please. Lord, I have one Supreme Court judgment, my lord. One apex court judgment, my lord.
Both judgments against NHA ಇದಾವೆ ನಮ್ಮ ಕೋರ್ಟ್.
Lord, I'll look into it. It may be passed on, 2:30 I'll produce.
Yes, Mr. Ladda.
My lords, if I may address to the arguments advanced by the petitioner till now. My lords, as per the NH Act itself, the section 3A is a preliminary notification under which a
We
brief
have
description.
already dealt with it and we have held against that contention.
My issue is the petitioner had pointed out at page number 30 that land plans and other details are to be inquired.
Yes.
Page number 31,
Yes,
that they may inspect the land plans at the office of competent authority.
yes. So
Malaj,
you want
the judgment.
everybody to come to your office and you will keep everything to yourself.
Malaj, please allow me to counter the judgment. The judgment that the petitioners are relying upon is the judgment of competent authority versus Barangur Jute Factory. In that judgment itself, my lords, if the
We
petitioner,
have dealt with both these aspects of the applicability of the Act of 2013
my lords,
and the aspect of Section 3A being a preliminary, final, and 3G notification where they can come and give the details.
my lords, what happens is, since it is after the publication of 3A,
We'll pass over the matter, see those two judgments.
At 2:30, my lord.
2:30, my lords.
Yes.
Great.
Obliged.
And both from Bangalore.
Please.
Monday on Section 3A and 3G.
Please.
The 2013 must be around a year or two ago.
Please. 2:30, lordship.
So. Auru Kotbudi, let him also see it.
24, we have still open.
Please.
Therefore, I had filed application getting.
Lord CPC.
Yes.
Sanjay Katgir.
Please, so defendant's writ petition, my lord. The original plaintiff, my lord, one Taiwa, files a suit seeking a declaration that one Durgappa, her husband, has executed a registered will dated 2/11/2016 in favor of defendant number 1 and 2, and also sought for a declaration to declare that she is the legally wedded wife of Durgappa, who has executed the will in favor of defendant number 1 and 2, my lord.
Yes.
My lord, during the pendency of the suit, my lord, the Durgappa died. Sorry, Taiwa died. Taiwa died.
Yes.
My lord, they filed an application under Order 22 Rule 5 to come on record as a, my lord, the legatees under the will, my lord.
Under which will?
Said to have been executed by Taiwa. My lord, the point for consideration is, my lord, there are two limb of arguments, my lord. One, my lord, is the very relief sought for by the Taiwa, saying that she is the legally wedded wife, has not yet, my lord, been decided.
Yes.
So, my lord, Ligawa had no, my lord, executable right in terms of Section 30 of Hindu Succession Act, my lord. My lord, point number one. The second limb of argument is whether, my lord, the trial court can postpone the decision of the due execution of the will, my lord, in the suit proceedings, my lord. The trial court, my lord, has to decide under Order 22 Rule 5 whether there is a due execution of will and, my lord, whether they prove the will. My lord, my submission is, my lord, the legatees under the will, my lord, have got an independent right to file a separate suit seeking a declaration. And point number two is the trial court shall decide whether they are the legal representatives, my lord, in terms of Section Order 22 Rule 5, my lord.
Inquiry was held?
Inquiry is not held. My lord, what they contend is, my lord, during the lifetime of Taiwa, had filed one application. Lord, I think.
Are you disputing the will executed by Taiwa, or are you disputing only the status of Taiwa?
We are disputing the status of the Taiwa.
You're not disputing Taiwa's will in favor of the impleading applicant.
Both we are disputing, Lord. First, we are disputing the very, Lord, the whether the Taiwa is the legally wedded wife.
That is still subject matter of the suit. Are you disputing the will executed by Taiwa in favor of this impleading applicant?
Impleading applicants.
The inquiry agbekala.
Inquiry. Lord, what they contend, Lord, is, Lord.
Your objections,
please.
Lord, Taiwa during her lifetime only, she filed application for amendment of the plain, and she narrated I have executed will in my favor, plaintiff, my lord. She has narrated, my lord. She herself, and that IA was allowed, my lord. Para 8 was added, my lord.
Who are you?
I was a brother's son.
Brother's son.
Yes, she died issueless, my lord.
Amended plaint B, na?
Yes, it is. In fact, I produce, even the petition counsel produced, my lord. Lordships may get at para 8B, my lords.
8B, executed will in respect to sounds in favor of Yellappa. She herself has said that there
No,
cannot be a
whether,
dispute.
my lord, it will, my lord, dispense with the proof of the execution of the will, my lord.
When she
Because,
has
my lord,
herself said,
whether that will has been executed, my lord, out of fraud, misrepresentation, or whether, my lord, it is surrounded by suspicious circumstances, whether, my lord, due execution of will, whether it cannot dispense with section 65 and, my lord, 68.
are you claiming under Taiwa?
No, no, my lord.
Then?
We are claiming under the registered will, my lord.
If you are not claiming under Taiwa, how are you disputing the will when she herself has said that she has executed will?
That's why, my lord, that's why I submitted, my lord. If they contest that Iowa has executed a will, they cannot, my lord, represent Iowa, my lord, in the present suit where Iowa had sought for a declaration to be the legal advocate.
They can continue. They can continue the relief because until that declaration in terms of prayer B is A1 is not granted, they cannot get any right. Can they file a suit by themselves to ask for a declaration that Taiwa is the legally wedded wife of Durgappa Basalingappa Bavi?
Durgappa, my lord, has executed registered will in favor of defend number 1.
That is the issue. Decree to be passed declaring that the alleged will dated 2/11/2006.
And it will declare that she is the legally wedded wife. Yes, ma'am.
So until she gets declared as a legally wedded wife,
Please, ma'am.
they won't get a right and they can continue this suit by stepping into our shoes. They step, as a legatee, they step into our shoes.
But without there being, my lord, inquiry,
Then Para 8B there last year.
Para 8B there, whether it will dispense with the proof of section 65 and 68.
That will dispense with it when she herself has made a statement. When she has accepted it and there is a pleading to that effect, not required. Petitioner is before this court seeking for the following reliefs. One, Taiwa had filed a suit in OS number 342 of 2017 seeking for the following reliefs, page 29. 30. During the pendency of the said suit, the said Taiwa expired. Thereafter, an application came to be filed by one Sri Yellappa Kempanna Badigawad to come on record as a legal representative of deceased Taiwa, claiming that a will has been executed in his favor, bequeathing the properties subject matter of the said suit in his favor. The said application was opposed by the defendant in the said suit, who are the petitioners herein, contending that the will has not been executed in a proper manner. The will would have to be required to be proved before the application could be considered. Unless the will satisfy the test of law, the application cannot be considered. The trial court rejected the said objections and allowed the application via the impugned order dated 20th March 2024, which is under challenge in these proceedings. Shri Nilopan, learned counsel for the petitioner, again reiterates the objection which has been filed and submits that the manner in which the will has been executed is not beyond doubt. He contends that the petitioners had been looking after Taiwa and there was no reason for Taiwa to execute the will in favor of the applicant. The applicant being the son of the brother of Taiwa, he is not a legal heir of Taiwa and he cannot therefore come on record as a legal representative. The impleading applicant has not sought any relief to declare the will to be valid, and in the absence thereof, the application could not have been considered by a trial court. Shri Sanjay S. Category, Learned Counsel for the respondent, submits that the said Thayawa during her lifetime had filed an amendment application in OS number 342 of 2017.
Yes.
And by way of the said amendment, para 8B has been inserted in the plaint, wherein the said Thayawa has categorically admitted the execution of the will in favor of the applicant. And that statement being part of the pleadings filed by Thayawa, there would be no requirement of any further proof of the will. Such proof would be required only if there was no categorical admission by the testator as regards the execution of the will. Both the will having been accepted to have been executed by the testator, the said will having been registered with the office of the sub-registrar, copy of the will having been produced along with the amendment application and forming part of the records of the suit, there was no requirement for any detailed inquiry, so long as the testator had admitted the execution of the will. No objection could be raised by the defendants in the suit, who are the petitioners herein. Heard so and so peruse paper. The short question that would arise for consideration in the present matter is whether a legatee under a will is required to prove the will if the testator has already admitted the execution of the will in a proceedings before a court. The contention of Shri H. Nilopant, Learned Counsel for the petitioner, is that whenever anyone propounds a will, the said will has to be established in the manner known to law, satisfying the requirement of Section 65 of the Indian Evidence Act. You again, Appa? Section 65 is now what?
The two attesting witnesses have to be examined.
Your section change ಆಗಿದೆಯಾ same?
ಇಲ್ಲ.
Evidence Act is la change.
Evidence.
65 of the Evidence Act.
Section change.
He submits
Change ಆಗಿಲ್ಲ.
that unless the said will stands the test of law and is established by seeking for necessary relief in regard thereto, the will could not have been accepted by the trial court, and the applicant could not have been treated as a legatee and be permitted to come on record. This contention would have been true if there is a dispute between any persons claiming under the will and or the right of any party be affected by the will. The suit had been filed by late Thayawa seeking for a declaration that another will executed by one Durgappa Basalingappa Bhavi in respect of suit properties in favor of the defendants therein was illegal, unlawful, null and void, and for a further declaration that the said Thayawa is the legally wedded wife of Durgappa Basalingappa Bhavi, and as such she is a class 1 legal heir. Before the said suit could reach its logical end, Thayawa expired. The applicant sought to come on record as a legatee of Thayawa in persons of will dated 12/9/2017 registered with the office of the sub-registrar, Gokak. The said Taiwa, apparently by way of abundant caution, apprehending that there could be a dispute raised as regards the will in future, which has been executed in favor of the son of her brother, had filed a amendment application in the said suit and had got inserted para 8B in the plaint. The said para 8B reads as under page 28. A perusal of this aforesaid para would indicate that she has categorically made a submission that she has executed a will in respect of the suit properties, bequeathing the suit properties in favor of the applicant Sri Ellappa, son of Kempanna Badigwad of Madwal village, out of love and affection, while she had sound disposition and that the will and of her own free will and wishes. Such a statement which has been made, such a pleading which has been made in the said suit is part of the, would indicate, by producing the will, would indicate a categorical admission made by the testator of the execution of the will. Once a testator has admitted the execution of a will in a proceedings before the court and pleadings are filed, I am the considered opinion that there would be no requirement to further establish the authenticity of the will in terms of Section 65 of the Indian Evidence Act, since the testator herself has categorically admitted both the execution, the veracity, and the contents of the will. Admitted the execution, veracity, and the contents of the will, and has herself produced the will in the said suit. Thus, I answer point number 1, point raised by holding that if a testator were to admit the execution and the contents of a will in a court proceedings, there would be no requirement to further prove the veracity, further prove the execution and the veracity of the will in terms of Section 65 of the Indian Evidence Act. In that view of the matter, the contention of the counsel for the petitioner are rejected. No grounds made out. The petition stands dismissed.
However, it may be clear that the fact that they have come on record, they have to establish, my lord, independently the relief sought, my lord.
Needless to say, needless to say that insofar as the release which had been filed as claimed by Taiwa in OS number 342 of 2017, the same would have to be established in accordance with law by the person who has now come on record as the legatee stroke legal representative of the deceased Taiwa.
Please.
All contentions relating thereto are kept open.
Lordship said 68 section 68 and
68 of
evidence Act. 68 and 70 ಅಂತ. Lordship said 65.
ಸರಿ ಇಲ್ಲ 65
ಅಲ್ಲಲ್ಲ
ಅಂತ ಅದಕ್ಕೆ ಕೇಳಿದ್ದು.
yes, the change ಏನು ಆಗಿಲ್ಲ. Continue. The ಸಾಕ್ಷಿ ಅಧಿನಿಯಮ it is
of the ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲ
ಅಲ್ಲ ಹಳೇದು ಅದೇ ಇತ್ತು.
ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ.
ನಾವು 68 ಮೇಲೆ section
2023 section 68
even 70 ಬರ್ಬೋದು in fact
and 70 of the ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ.
Please, oblige.
65 replace ಆಗುತ್ತೆ. ಇನ್ನ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲೇ ಇರ್ತದೆ.
25
70 which are reproduced here under for easy reference.
I beg to apply to the petitioner.
Stay.
The respondents have filed this
Mr.
application.
Amir
for
Ahmad.
vacating.
Dr. Amir Ahmad Bagali.
With your pardon.
ಯಾರು?
Amir Ahmad Bagali.
ನಾನು ನೋಡಿಲ್ಲ.
Counsel for respond number 8 to 10.
ಗೊತ್ತಿಲ್ಲ ನಂಗೆ.
ಗೊತ್ತಿಲ್ವಾ ನಿಮ್ಗೂನು? ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅನ್ನೋದು.
ಬಂದಂಗಿಲ್ಲ ಅವರು.
ನಿಮ್ಗೂ ಗೊತ್ತಿಲ್ವಾ? ಇದರ
Both husband and wife will lost practice.
ಬರ್ತಾರಾ?
Kindly you lost. They are not. I have not seen them today.
Though counsel for the petitioner is present and ready to address arguments, none appears for respond number 8 to 10. In order to provide one more opportunity for respond number 8 and 10, 8 to 10 to be represented, relist on 24th January. If none were to appear for respond number 8 to 10 on that date, matter would be taken up for consideration on the basis of submission made by the counsel for the petitioner. Interim order earlier granted is extended till next day.
Interim order arrest.
26 Dayanand Bandi.
Lord, in execution of a money decree, the petitioner was committed to civil prison.
Dharwad, Mutunjay Elkeri.
One submission.
Not Hegde. Mutunjay Elkeri ಅಲ್ಲಿ. ಯಾಕೆ ಬೇರೆ ಬೇರೆ ಇದು?
Some things have transpired which I may, subject to what my learned friend would submit, I'll just submit. During pendency of consideration of all these matters, my lord, the petitioner was released from civil prison by virtue of an interim order granted by this honorable court. He was present. He assured my lord to settle the matter. Lord, I agreed to give him 45 days time. Nearly 6 months thereafter have elapsed. He has not paid a single pay. Again, NBW has been issued before the executing court. Today I am instructed that my lord, he is absconding. I don't know my lord, our then instruction is but even today my lord, my submission would be, my principal amount itself is my lord 1 crore 18 lakhs. I was agreeing for settlement nearly about 1 crore rupees. But he has to at least my lord show bona fides by paying something before.
ಇನ್ನು 1 crore 1 ಪೈಸಾ ಕೊಟ್ಟಿಲ್ವಾ?
ಒಂದು ಇಲ್ಲ ಇವತ್ತಿನವರೆಗೂ ಇಲ್ಲ. 2016
Initially at the time of execution, my lord, once he paid 11 lakhs and once he paid 7 lakhs.
Allah, that was before the execution.
After that, he hasn't paid anything, my lord.
So today if he wants any
What has
further relief
happened
from
is
this honorable
all the
court,
properties are attached here, attached in the execution. Now he cannot sell them. At the same time, whatever was, because it was under mining business. So my lord,
ಪ್ರಾಪರ್ಟಿ ವ್ಯಾಲ್ಯೂ ಎಷ್ಟು?
property value ಇದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಇದೆ.
lot of properties are there.
So initially when
Now, this honorable court on the last occasion after hearing
ಒಂದು ಪ್ರಾಪರ್ಟಿ 1 crore ಇದೆಯಾ?
ಅವರು ಅದನ್ನ,
ಜಾಸ್ತಿ
that's
ಇದೆ.
why this honorable court
ಜಾಸ್ತಿ
after
ಇದೆ.
hearing for some time on the last
1
occasion,
crore ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಬಿಟ್ಟು
he was directed to produce the material before this honorable court or to show what endeavor he has made to sell or the value of the properties. ಅದು ಏನು ಮಾಡ್ತಾ ಇಲ್ಲ.
ಮಾಡ್ತಾರ ಇಲ್ವಾ? ನೀವು ತಗೊಂತೀರಾ ಒಂದು ಪ್ರಾಪರ್ಟಿ?
ತಗೊಳಕ್ ರೆಡಿ ಇದೀವಿ. ಅದು particulars ಕೊಟ್ರೆ ಅದನ್ನಾದ್ರೂ ಕೇಳ್ತೀವಿ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಟ್ಕೊಳ್ಳಿ ಅವ್ನು ಪ್ರೆಸೆಂಟ್ ಇಟ್ಬಿಡ್ತೀನಿ ಯಾಕಂದ್ರೆ
ಬರ್ಲಿ.
You of all this just transfer on property. ನೀವು ಸೇಲ್ ಗೀಲ್ ಎಲ್ಲ ಬೇಡ. ಅವ್ರ ಆಮೇಲೆ ಏನಾರ
ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಮರ?
ಅಲ್ಲಿ
Sisters have come up now. Sisters have come up.
ಎನ್ಕ್ವೈರಿ ಹಾಕಿದ್ದಾರೆ.
Sisters have come up saying that we have a share in the property. His sister.
Get them also to execute. Sisters have been set up by him only.
Understood.
ಅದು ಆಗಿರ್ಬೋದು, ಏನ್ ಗೊತ್ತಿಲ್ಲ ಅದನ್ನ, ಯಾಕಂದ್ರೆ ನಾವ್ ಹೇಳಿಕ್ ಆಗಲ್ಲ.
No, my friend may not say it, but I can very well say it loudly.
Get them to execute.
ಅಲ್ಲ ಒಂದ್ 10 days ಆಕ್ಚುಲಿ ಅವ್ನು ಕೊಟ್ಟೇ ಇಲ್ಲ. ಆಕ್ಚುಲಿ ಅದನ್ನ ಮನಿ ಸೆಟ್ಲ್ ಅಂತ ಹೇಳಿ ಇಬ್ರು ನಡಕ್ಕೆ ಕಮ್ಯುನಿಟಿ ಎಲ್ರೊಬ್ರು ಬಂದ್ರು, ನಾವು ಸೆಟಲ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೋದ್ರು.
ಇವಾಗ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ ಮಿಸ್ಟರ್ ಬಂಡಿ?
ಹೌದು, ಅದನ್ನೇ ನಾವು ಇಮಿಡಿಯೇಟ್ಲಿ 45 ದಿವಸದಲ್ಲಿ ದುಡ್ಡು ಕೊಡಿಸ್ಬಿಡ್ತೀವಿ ಅಂತ ಹೋದ್ರು. ಅದನ್ನ ಇವ್ರು ಪಾಪ ಹೇಳಿದ್ರು 24% ಇಂಟ್ರೆಸ್ಟ್ ಬೇಡ, ಕಡಿಮೆ ಮಾಡಿ ಅಂತ ಹೇಳಿ. ಸೊ ಅದನ್ನ ಮನಿ ಎಷ್ಟು ಅಂತ ಹೇಳಿ ಅದೇ ಸೆಟ್ಲ್ ಆಗಿಲ್ಲ ಇನ್ನು. ಅದನ್ನ
1 crore
ಅದು ಅಲ್ಲೇ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅದು ಕಾಂಪ್ರಮೈಸ್ ನಲ್ಲಿ ಇವ್ರು ಇಳಿಸ್ಲಿಕ್ಕೆ ಒಪ್ಕೊಂಡ್ರು, ಅವನು ಸ್ವಲ್ಪ ಇದನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ ಒಪ್ಕೊಂಡ.
ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟು?
ಯಾವ್ದು ಇಲ್ಲಿ ನಮ್ಮವನು ಏನ್ ಮಾಡಿದ?
According to the execution we go, it will be nearly 2.5-3 crores as on today.
2 crores
we have
initially it was 60 lakhs, now it has come to 2 crores.
Go on further. If there's any property that you are willing to transfer, they are willing to take it.
My contention is only this. However, I don't.
They are willing to pay the stamp duty also. You don't pay stamp duty.
ನನ್ ದುಡ್ಡು ಕೊಡ್ಲಿಕ್ಕೆ ಇವನು ಕೊಡ್ಲಿ ಅಂತಾನೆ ಇದೆ. ಅದಕ್ಕೆ ನಾವಿಬ್ರು ಟ್ರೈ ಮಾಡಿದ್ದವಾಗ, ಯಾಕಂದ್ರೆ ಸಿವಿಲ್ ಪ್ರಿಸನ್ ಮುಗಿಲಿಕ್ಕೆ ಇನ್ನೊಂದು 7 ದಿನ ಇತ್ತು ಹೊರಗೆ ಬಿದ್ದು. ನಾನು ಇವ್ರಿಗೆ ಹೇಳಿದೆ 7 ದಿನ ಆಗ್ಬಿಡುತ್ತಂದ್ರೆ ಅವ್ನು ಏನಾದ್ರು ಮಾಡಿದ್ದಾನೆ.
So now what I agreed for, my lord, he is released from prison before this honorable court, so that he pays something.
Only thing is, my lord, now again arrest warrant has been issued. Now that is sub judice before this court. The trial court has issued one more warrant on the very same application.
Because the interim order did not continue.
So ಅದನ್ನಷ್ಟೇ ಸ್ಟೇ ಮಾಡಿ ಒಂದು 10 ದಿನ ಬಿಟ್ಟು ಇಟ್ಕೊಂಡ್ರೆ ನಾನು ಇಲ್ಲಿ ಇಡ್ತೀನಿ ಅಕಸ್ಮಾತ್.
I have complete opposition for this submission. Let him be present before this honorable court.
He won't stay anything.
Yes, show bona fides, pay something, my lord. Then, my lord, he may be further relief may be granted.
ಅಲ್ಲ, ಅವ್ನು ಅರೆಸ್ಟ್ ಆದ್ರೆ ಕಾಂಪ್ರಮೈಸ್ ಪಾಸಿಬಲ್.
ಅರೆಸ್ಟ್ ಅಲ್ಲ, ಅಪ್ಸ್ಕೊಂಡಿದ್ದಾರೆ, ಅಲ್ಲಿ ಹೋಗೇ ಇಲ್ಲ ಅವರು.
ನೀವು ಇಲ್ಲಿ ಕರ್ಕೊಂಡು ಬಂದ್ರೆ ಇಲ್ಲೇ ಅರೆಸ್ಟ್ ಮಾಡ್ತೀವಿ, ದುಡ್ಡು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ.
ಅಲ್ಲಲ್ಲ, actually as of now, unless the property, my lord, as of a money, he is unable to pay. ಸೊ ಇದನ್ನ ಏನಾದ್ರೂ ಮಾರಿದ್ರೇನೆ ಆಗೋದು.
If he is not able to pay the money, let him transfer a property if you have so many properties.
ಅದನ್ನೇ ಈಗ ಅವ್ರ ಸಿಸ್ಟರ್ಸ್ದು ಇದಾಗೆ ಲೀಗಲಿ ಅದಕ್ಕೇನೆ ಅವ್ನು ಪ್ರೆಸೆಂಟ್ ಇಟ್ಬಿಡ್ತೀನಿ, ನನ್ಗೂ ಏನಿದೆ ಇಲ್ಲ ಅವ್ರಿಗೆ ದುಡ್ಡು ಮುಟ್ಬೇಕು ಪಾಪ.
ಅವ್ರು ಇಲ್ಲಿಂದಾನೆ ಎಳ್ಕೊಂಡು ಹೋಗ್ತಾರೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಸೇಮೇ ಆಗಿತ್ತು ಮರೋಡ್. He was present. ಇಲ್ಲಿ ಬರ್ತಾರೆ ಅವರು ಪ್ರಾಮಿಸ್ ಮಾಡ್ತಾರೆ. Then he does not even get into the hands of my learned friend also.
Both the councils released on 23rd January at 2:30 p.m. The counsel for the petitioner is directed to keep the petitioner present on the next date of
I'll
hearing.
voluntarily keep my party also present.
But meanwhile, at least for until 23rd, that arrest warrant is to be stayed.
ಸಿಗ್ತಾನೆ ಇಲ್ಲ ಅವ್ರು ಕೋರ್ಟ್
ಅಲ್ಲಿ ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಅದೇ ಹಣೆ ಬರ. ಯಾಕಂದ್ರೆ ಇನ್ನೊಂದು 7 ದಿನ ಆಯ್ತಂದ್ರೆ
ಅರೆಸ್ಟ್ ಆದ್ರೆ ಹಂಗೆ ಕೊಡ್ತಾರೆ.
ಅಲ್ಲ ಇನ್ನು 7 ದಿನ ಇದೆ, ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್. ಮೋಸ್ಟ್ ಆಫ್ 2 and
shorter date may be given in that case.
20th. 20th at 2:30.
ಅಡ್ಡಿಲ್ಲ. ಅಲ್ಲ ಅದನ್ನೇನೆ ಹೇಳಿದೆ 20th ಅಲ್ಲಿ ನಾಳೆ
ಇಲ್ಲ 27 ಇಷ್ಟೆಲ್ಲ ಆಟ ಆಡಿದಾನೆ ನಿಮ್ ಕ್ಲೈಂಟ್ ಅಂದ್ರೆ ಇಲ್ಲ.
23rd ಇರ್ಲಿ ಹಾಗಾದ್ರೆ.
23rd ಇರ್ಲಿಲ್ಲ 23rd.
27 Srivatsa Hegde.
For the respondent number 1, my lord.
Yes.
I have filed the application for vacating the stay, interim stay granted by this honorable court, my lord.
Ready?
Yes, my lord.
On merits.
Yes,
not
my lord.
only vacate stay. Ready?
Yes, my lord.
Yes, I would need a day's accommodation, Lord. Nevertheless, I would narrate the facts.
Nevertheless, beda. Argue or
I need a day's accommodation.
relist on 20th January.
My lord, there's an urgency because I filed a memo on the previous date of hearing. I've produced 2 photographs wherein the petition number 1 is constructing over the suit property during the pendency itself and during the stay order.
You can't construct.
This is a suit for partition, my lord, and there is a compromise which has taken place conclusively.
My lord,
he has received rupees 15 lakhs and also a gift deed. Now she wants to resign and
For the petitioner relist tomorrow.
Tomorrow.
It is made clear that no further adjournment would be granted.
Yes.
Interim order is extended till tomorrow.
Much obliged, my lord.
28 Prithvi KS.
Of mandamus, my lords.
Lord,
Pursuant to submission of representation before the respond number 7, that is PDO, he has issued a notice, my lords, to the respond number 9 and 11, my lords, to take appropriate action as per, my lords, rule 3 and 4 of the, my lords, Panchayat Raj rules 2011, my lords.
So nothing survives.
He has to conclude, my lords, due process.
being initiated,
That is to be concluded within time bound
Lord,
as per my lordship fixed.
my lord,
Of objections on behalf of respondent number 9 to 11 member. In fact, 9 to 11, they have filed a suit in which injunction has been passed against the Gram Panchayat member. And that is also placed on record by the respondent number 5 to 7. My lord, there is a road which is in existence much prior to the period of.
There's already a proceeding which have been started under section 3.
Proceedings have been started.
That suit
during the pendency of the suit. The suit
You
is.
place it on record before that authority.
Please.
We can't decide it in this. It's only a petition for mandamus.
Yes.
my lord, in
And
that respect,
in
my
that
lord, I have submitted my memo, my lord, dated 28/11/2024, my lord. My lord, their content, their representation seeking for mandamus is concerned, my lord, annexure L, wherein, my lord, it is the submission of the petitioner that, my lord, take action against for encroachment eviction is concerned, my lord, against one party is concerned.
Yes.
My lord, in pursuance of that representation, my lord, I have placed the records before the court. We have already issued notice, considered,
They are all, you have issued them notice.
issued already, my lord.
I'll reply to it.
They have given a reply also by stating that, my lord, civil suit is pending. And by obtaining the extract of the computerized copy, my lord, civil suit is pending and the injunction has been granted against the Gram Panchayat.
Pass orders so that they can challenge it.
My lord, in view of my kind submission, because their contention is only to,
You cannot sit on it. You have to
please,
pass
my lord,
orders.
please,
Once you have issued notice,
please,
either you reject is this one or
please, my lord.
allow it.
In view of pendency of civil suit.
Producing the survey reports along with the objections, my lord. As per the original records which were.
Can we decide that in a
But at
petition
least
for
all can be
mandamus?
taken on record.
Cody
and,
record.
yes.
Why are you wasting paper? You can use it somewhere else paper so. ಅಲ್ಲಿ ಕೊಡಿ ಇನ್ನೊಂದ್ಸತಿ ಅವ್ರಿಗೆ ಬೇಕಾದ್ರೆ.
Please.
ಕೊಡಿ why ಇಲ್ಲಿದ್ರೆ ಏನಕ್ಕಪ್ಪ?
As per this.
ಇನ್ನೊಂದು 2 ವರ್ಷ ಆದ್ಮೇಲೆ it will have to be shredded. No need of those papers. Petitioner is before this court seeking for the following reliefs. Learned counsel for respondent number
5 to 7.
5 to 7 has filed a memo dated 28/11/24 stating that a notice has been issued to respondent number
9 to 11.
9 to 11 on 15/6/2024, which has been replied to by them.
Additional objections also, that permission may kindly be given to.
Replied to by them, and necessary orders would be passed shortly.
Please.
Has been replied to by them. He submits that on the basis of the reply received, which has been replied to by them, full stop. He submits that on the basis, after considering the complaint by the petitioner and the reply made by respondent number 9 to 11, necessary orders would be passed.
As per rules.
9 to 11. Shri Sangram S. Kulkarni, learned counsel for respondent number 9 to 11, seeks permission to file additional documents. He is so permitted. Once the he is so permitted to file on or before?
Milord.
On or before 17 January.
My kind submission. It's only endorsement will be speaking, Lord, in view of pendants of civil suit and injunction is pending against the Gram Panchayat. Lord, no, it will be subject to result of the civil suit. That is only the endorsement, Lord. If the parties are permitted to produce the documents, Lord, it will confusing the authorities.
He is entitled to file anything.
Please, please, in addition.
Notice court, well, he is
Please.
entitled to file. You
Please.
can't withhold. It will be part of your record.
Please.
Then the process will go from there. Other appeal ella agata.
Please, please.
Is so permitted. Respondent 5 to 7 are directed to consider the same and pass necessary orders within 15 days thereafter.
Certified copy possibilities of documents they permitted to produce.
Certified copy produce madila and reject madi. Our both the end produce madbeku. You cannot be directing everything.
Please.
It's made clear that this court has not expressed any opinion on the merits of the matter. It is for respondent number 5 to 7 to pass orders on merits.
As per that Panchayat Raj rules, my lords, 2011. It has to be followed, my lords.
Pending I stand disposed.
Please.
29, Mrutyunjay, Hallikeri.
Lord, the respondents have entered the land of the petitioner, lords, without a final notification, passing an award, taking possession.
I appear for respondent number 2, my lords.
At page 34, your lordship, I see
Lords,
they have caused damage.
I request to take up on, my lords, 21st, my lords. My statement of objection is finalized to secure some documents in connection with that, my lords. In the mean,
acquisition notification agilva.
Only preliminary.
19.
After filing the writ petition, my lord, but taking a lot of time, they bring a final notification.
Proper objections. If you do these kind of things without the acquisition being complete, your officers will be hauled up. See page 34.
What's
ಏನು ಅನ್ಕೊಂಡಿದ್ದಾರೆ ನಿಮ್ಮ officers?
Before that, it was possession was taken.
How can you take possession on a preliminary notification?
That is.
This KNNL, CNNL, your officers think no end of themselves. We already passed strictures against few of the officers. This will result in serious disciplinary action to be taken.
Yes.
They can't be doing this.
And another two things, my lord, I'll bring it to your lordship notice.
So that it comes to his notice.
Yes, my lord. At page 28, my lord, they have page 28, my lords. They have diverted, my lord, the line in order to save the property of other person. Page 28.
That is a note that you will have your objections. That will
No,
be
my lord,
considered.
they have drenched it, my lord, by diverting that.
That is
by diverting their own plan in order to save the other's property. They have caused damage in my property.
It is totally incorrect statement.
This is my another objection. Third, my lord, when I objected for this, the Tahsildar and PSI have threatened me. I have given, my lord, representations to that effect. They have not taken any action to that effect, my lords.
You are government officers, so all the government officers will act at your whims and fancies.
I'll secure instructions insofar as this deviation concern
One
is
government officer calls the police inspector will go and threaten them.
that instruct.
Abuse of the official powers. There's fraud on power.
I'll
Please warn them properly and file your objection.
Please.
Counsel for respondent number 2 to 4 seeks for and is granted a week's time to file a statement of objection. If objections are not filed by 17th, the same will be taken as not filed and matter proceeded with. Relist on 22nd. Who is this proposed?
My lord, he is a contractor who has entered the property without, my lord, notifications.
Will allow. Accepting the reasons stated in support of IA2 of 2024, the impleading applicant being the contractor who has carried out work on behalf of respondent number 2, the said application is allowed. Since if any action is to be taken, the same would also have to be taken against the contractor. Counsel for the petitioner to carry out necessary amendment and file amended cost title. By accepting the reasons stated in support of IA1 of 24, the production of certified type copy of Annexure C is dispensed with. Relist on 22nd, interim order earlier granted is extended till next day.
Please.
30, Prashant Usmani.
That's one submission. My lords, in the last occasion, my lords, in the last bench, since my senior colleague was suffering through ill health, Shri Viresh Budhiraj sir was appeared in this matter and he argued the matter, my lords. This matter is reinterested to Shri Viresh Budhiraj. So I request
his name has to be entered.
shown, my lords.
Registry is directed to print the name of Shri Viresh Budhyal as that appearing for respondent number 2 and 3 and delete the name of Shri G.I. Gachinmat as that appearing for respondent number 2 and 3. Post the matter before a bench of which SGRJ is not a party.
Please.
Since there is some urgency in the matter, my lords, may I, no, for
Yellow
early
note between
posting
you.
of the,
We cannot direct that.
please.
Please, grateful.
31, AC Chaklabi.
Lords, in this case, I need 2 days time, lords.
Give your time. Order stay vacated.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಏನು ಫೈಲ್ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗಿದೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎನಿ ಡೇಟ್
Counsel for the petitioner seeks for and is granted
15
a week's time to get ready and address his arguments. Released on 22nd. Interim order earlier granted is extended till next.
please much over please
32, KR Anand.
Labor. Yes, Mr. Anand.
32.
My lord, I appear for the respondents, my lord, along with my colleague, Mr. Hanmantadi Saukar.
Yes, Anand is also here. Mr. Anand.
Am I audible, my lord?
Yes, but we can't see you.
One second. Now, my lord?
Yes.
My lord, the IA number 1 of 25 is filed by the petitioner. Now, brief background let me give to my lord.
What is the amendment you are seeking for?
My lord, the order that is under challenge is for a period of 32 months. Directing payment of wages to the workmen under the provisions of Payment of Wages Act. Holding that I have violated section 25M and 25O of the Industrial Disputes Act.
Objection, Mr. Chirandaya, to this application.
My lord, that application, my lord, is an independent cause of action, my lord, where the workers, my lord, have filed an application for the subsequent period. It doesn't pertain.
Consider both the matters here and pass on.
Now, in fact, my lord, this will not take more than 10 minutes, my lord. Your lordship may hear this matter because these people have not been paid their wages, my lord, for the last.
No, we'll hear you.
Yes, my lord.
If we allow the amendment, if you want to file any objection, you file it also and we'll hear you.
My lord, that application can be allowed, my lord. I have no objection to allow that application. But if this main matter itself is heard, my lord. The date may be fixed, my lord.
Amendment allow admel additional objections ಏನಾದ್ರು ಇದೆಯಾ ಇಲ್ವಾ?
That is, additional objection will not come, my lord, because the reason is that is for the subsequent period, my lord, authority will consider.
Right. By accepting the reasons stated in support of IA1 of 24, the additional grounds, the additional facts, grounds, and prayer are brought on record. Counsel for the petitioner to carry out necessary amendment, file amended petition. By accepting the reasons stated in support of IA 1 of 24, the dispensation, the production of certified copy of Annexure C is dispensed with in view of the fact that there is no particular opposition as regards the veracity, in view of the fact that there is no particular opposition as regards the veracity of the said document. List of authorities have been filed by both.
Both.
No, it is filed by the only petitioner has filed.
Petitioner has filed. You file madilva.
Milord,
You want to file any list of?
Milord, we are relying on the very same or judgment relied on by them to show that Milord, the petition is maintainable.
The amendment,
The sole issue is, Milord,
the submission of Shri Chirande LM Learned Counsel appearing for respond number 1 to 26 and 28 to 73, that he does not wish to file any additional statement or objections to the amended petition is placed on record.
Milord, I'll file additional objections to the amended petition, Milord. But I'm
ಇವತ್ತು ಹೇಳಿದ್ರೆ ಏನಾದ್ರು ಮಾಡ್ಬೇಕಂತ ಬೇಡ ಅಂದ್ರೆ
I have nothing to add so far as the judgments are concerned, Milord. Then I have to file objections to this, the additional statement of objection.
Shri LM Chidande seeks for and is granted 10 days time.
Yes.
To file additional statement of objections to the petition, which shall be filed on or before 21st January. List of authorities ಏನಾದ್ರು ಇನ್ನ additional file ಮಾಡ್ತೀರಾ ನೀವು?
I have nothing to file, Milord. Only they have filed petition.
The submission of Shri L.M. Chidananda that he does not wish to file any list of authorities or rely on any other judgments apart from the judgments already placed on record by the counsel for the petitioner. He is placed on record. Relist on 24th January.
Milord, may I submit, Milord, well, at least some 50% of the wages that can be released to these workers, Milord, they are without
Interim order stay has to be extended.
Milord, I must point out, Milord, the sole ground urged in this writ petition is, Milord.
In another 10 days, nothing will happen, Mr. Chidananda. You address arguments, we will hear it.
Please.
There is no further, nothing will come in the way now to consider it.
Please.
Interim order has to be extended.
Interim order earlier granted is extended till next day.
So your lordship may kindly say, lordship say additional statement of objection. We are not at all filed objection. Lordship
Not filed objection.
Not.
Objections filed ಮಾಡಿದೆ argument ಮಾಡ್ತೀನಿ ಇದು ಬೇಕು.
But what
Modify ಮಾಡುವಂತ.
what we have stated before the authorities is our objection. That is there.
Statement of objection stroke additional statement of objection.
Please.
53, Shant Kardevar.
Lord, I appear for the petitioner. Lord, I am seeking Lord writ of mandamus.
Yes.
Lord, he is a student of MBBS, Your Lordship. Has completed, my Lord, MBBS, my Lord, course, Your Lordship, in the year 2021. And subsequently, my Lord, he did not, my Lord, attended to the, my Lord, internship. Because of that reason, now they are not permitting.
No order has been passed on your representation.
Yes, Your Lordship.
He is supposed to join immediate after passing of the MBBS examination final year.
Pass an order so that he can challenge.
Already we intimated to his parents.
They have sent papers to the university, my Lord, for seeking permission.
To university as well as parents, my lord, to join. And, my lord, as per regulation, he has to complete after passing of the MBBS examination. He has to complete internship within 2 years.
Please suggest what is to be done. Ante you are asking the university.
Yes.
Our university yaru?
Avinash, respond number 1. Avinash Bankar.
Where is Avinash?
He is out of station, my lord.
Petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the representation dated 7/3/2024 at Annexure H submitted by the petitioner seeking permission to rejoin internship has not been considered. The counsel for respond number 2 submits that the respond number 2 in furtherance of the representation has returned to the first respondent university on 7/3/2024 seeking the advice of the university. However, no reply has been received in relation thereto, and as such respond number 2 he is unable to go ahead with the request.
Yes, sir.
of the petitioner. In that view of the matter, respondent number 1 is directed to consider the representation submitted by the petitioner dated 7/3/2024 at Annexure H and the letter dated 7/3/2024 addressed by respondent number 2 college to the university within a period of 15 days from the date of receipt of a copy of this order.
Please. And one more aspect, my lord, they are relying some regulations which are not applicable to this.
Adi Idral Barakala, your mandamus.
Please.
If they reject, then you have to file another petition.
Please, notes.
IA 1 of 24 is allowed. Dispensed.
34, Ayush Bhatt.
My lords, I'm here, my lords.
My lord, in this, I seek 2 weeks time to file objection to main petition, my lord.
My lords, my
objection is LB. To cancel the building permission.
Please, my lords.
You are the Umesh Ainapur, standing counsel.
Ainapur.
I appear for respondent number 3, my lord.
The counsel for respondent number 3 seeks for and is granted a week's time to
Two-
file a
2 weeks
statement of
time.
objections.
2 weeks time.
2 weeks in it. Katbidtira ಆಮೇಲೆ.
ಇಲ್ಲ ಹಂಗಿರಿ ಕಟ್ಟುದು ಸರ್.
ಕಟ್ಟಲ್ವಾ?
Actually ಏನಾಗಿದೆ,
We'll
actually
record
there is an
your-
open space in front of my house.
He'll record your submission that you are not going to construct, then give you 2 weeks.
Actually ground floor is actually over, my lord. Well, it's over, actually the ground floor is
Put
over.
up the first floor.
First floor is, he's objecting when the first floor is being constructed.
No, my
And
lords, I
actually
have
ground
filed.
floor is an old building.
Will you go ahead with the construction or will you stop construction? If you are going ahead with construction, we'll pass an order. We'll record
Till
your-
next date of hearing.
The learned counsel for respondent number 3 seeks for and is granted 2 weeks time to file a statement of objection. Until then, respondent number 3 is restrained from putting up any further construction. Relist on 31st January.
Please.
IA 1 of 24 is allowed, sir, the production certified copy of Annexure B is dispensed.
35, Sachidanand Babaji.
My lords, the petitioner, my lord, her husband had purchased the property, my lord. Subsequent to that, he got the land converted for commercial purposes, NA, my lords. Subsequent to that, he also obtained permission from the 4th respondent to run a dhaba, my lords. My lord, after his death, now his wife made an application before the 4th respondent to get her name entered in the property, my lords, property register. Now that is refused on the premise that the NA order, which was originally given, the conditions of any order has not been complied. But
Which condition has not been complied?
my lord, section, my lord, page number 26, my lords, the 4th respondents has issued an endorsement saying that ಬಿನ್ ಶೇತಿ ಆದೇಶ ಹೊರಡಿಸಿದ 2 ವರ್ಷಗಳಲ್ಲಿ ಭೂ ಪರಿವರ್ತಿತ ಜಮೀನನ್ನು ವಾಣಿಜ್ಯ ಧಾಬಾ ಉದ್ದೇಶಕ್ಕಾಗಿ ಮಾತ್ರ ಉಪಯೋಗಿಸಿಕೊಳ್ಳತಕ್ಕಿದ್ದು ತಪ್ಪಿದಲ್ಲಿ ಈ ಬಿನ್ ಶೇತಿ ಆದೇಶವು ತನ್ನಿಂತಾನೇ ರದ್ದಾಗಿದೆ ಎಂದು ಪರಿಗಣಿಸಲಾಗಿದೆ. My lord, subsequent to this, my lords, there was a, my lords, I have obtained permission well within time, my lords, and also began the working of the dhaba as well, my lords. Now, in spite of that, there is a notification which is given by the first respondent to the effect that once NA orders are given,
Who is the contesting respondent?
Lords, I am the contested respondent.
4th respondent.
What is your purpose of this 2 years?
Lord, the deputy commissioner, my lord, the order.
What is the purpose of this 2 years? Once the land is converted, you will again put it back as agriculture land after 2 years.
Lord, a day before yesterday, my lord, I filed wakalat. Next date, any date, my lord.
You will have to answer that.
My lord,
Once
My-
conversion order, it cannot be.
There is no purpose in this 2 years.
It has to be within the period of 55 days.
There is no reason for that 2 years.
my lord, one submission.
You know, on condition ಆಗ್ತೀಯ, you're ಯಾರೋ ಏನೋ, you are giving reason for them to use their powers.
Even in
My lord,
terms
there
of
is a, my lord, there is a notification by the deputy commissioner saying that once land is converted for any order, it states in perpetuity, a person who has got the conversion order need not approach the DC, deputy commissioner for, now he says that since your any order you have not developed the land within 2 years.
Where is that condition?
My lord, that condition is forthcoming in the NA order. It is forthcoming at page number 26, my lords.
26.
26, it is forthcoming at serial number 11, my lords.
Yeah.
But my lords, I have developed the land well within period of 2 years.
ನಿಮ್ ಕಂಡೀಷನ್ ಹೊಡೆದಾಕಣ ಅಂದ್ರೆ ನೀವು ಬರೀ ಡೆವಲಪ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ. Learned AGA is directed to secure instruction and make a submission as regards the requirement of imposition, the reason and the requirement for imposition condition of developing a converted land within 2 years from the date of conversion. Relist on 22nd January.
Please, grateful.
IA 1 of 24 is allowed.
36, I1 of 24. 36, Sanjay Chinal.
Lord, in view of lapsing of a time by virtue of interim order, no confidence motion date was Lord, already lapsed. Fresh, it may be Lord.
Similar matters the lordship was pleased to dispose of.
Yes. Monday.
18th Lord.
Petitioner is before this court seeking for the following reliefs. A similar issue has been decided by this court, by coordinate bench of this court, by order dated 19 December 24 in WP number 107686 of 2024. In that view of the matter, I pass the following order. Page E order. ನಿನ್ನೆ ಒಂದ್ರಲ್ಲಿ ಮಾಡಿದ್ರೆ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡಿ. IA 1 of 25 stands disposed.
37, Jagdish Patil.
Here for the respondent number 3, my lords. Filed I for vacating, my lords, interim order. The I appear for respondent number 3. Filed, my lords, vacating of the interim order. The
Before that, Your
petitioner,
Lordship, may I just make on submission. The IA filed by the secretary of the Gram Panchayat. How he is aggrieved, Your Lordship, it is not.
Because the
Argue
election has
on
to,
the merits, Mr. Patil.
Yes, Your Lordship, that definitely, yes.
Vacate stella is no use.
my lords, the
Our should have.
please.
Petitioner our.
Yes, Your Lordship. The present petitioner, he was a vice president. He submitted a resignation on 4/12/2024, Your Lordship.
Yes.
That is first, Your Lordship, that the second B, Your Lordship, the annexure B in page 16 typed copy. Before that, Your Lordship, that it was mentioned 4/12/2024 for the Gram Panchayat on 1:20 PM. And before the AC, that is also on 4/12/2024 to 4, Your Lordship. On 16,
4/12 time ಎಲ್ಲಿದೆ?
typed copy ಅಲ್ಲಿ ಅದ್ರಲ್ಲಿ ಬಂದಿಲ್ಲ, ಅದು ಈ ಕಡೆ only.
Page 15, the
Page 15.
It is not disputed.
1:20
Yes,
PM
Your Lordship.
ಇಲ್ಲಿದೆ. Yes.
It is not disputed.
Subsequently.
Subsequently.
120 ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
Yes, Your Lordship.
ಏನಾದ್ರು ಇಶ್ಯೂ ಇದೆಯಾ ಅದ್ರ ಮೇಲೆ?
ಇಲ್ಲ, ಅದಕ್ಕೆ ನಾನು ಅಂದೆ.
Yes.
Subsequently, Your Lordship, he filed an application, representation to withdraw the said resignation on, Your Lordship, that even though it is dated 14/12/2024, it was submitted on 16/12/2024.
Within a period of 45 hours.
10 days. Within 10 days. But what has happened on 13th and 14th, Saturday, second Saturday and Sunday. That was the issue, Your Lordship.
ಅಲ್ಲಿ ಕ್ಯಾಲೆಂಡರ್ ಕೊಡಿ.
December.
24, 14/12. Second Saturday,
Yes,
Sunday.
Your Lordship. I could not make a.
The next Monday you file.
Yes, Your Lordship.
My lords, if as per my lords, section 48, subsection 3 of the Gram Swaraj and Panchayat Raj Act, lords, it says if within 10 days of acceptance of his resignation letter, if it is not withdrawn, then there is, my lords, a deemed acceptance of his resignation letter and he is resigned.
In acceptance ಅಲ್ಲ, within 10 days ವರೆಗೂ ನೀವು accept ಮಾಡಂಗಿಲ್ಲ. 10 days he has time to withdraw.
My lords, may I, my lords, read for a moment. What it says is every resignation under subsection 1 shall take effect on the expiry of 10 days from the date of its receipt by the assistant commissioner.
Yes.
It is received on 4/12.
Yes.
10 days, my lords, would end on 13/12. 4th, it is received. It is accepted. The 10 days expires on 13th.
Calendar code.
The further words, Your Lordship, that as the.
Section code, section 45,
48
subsection
subsection 3 or also.
Fourth would have to be excluded.
No, it says from the receipt of, my lords, the resignation letter under subsection 1. So fourth it is received. There is an endorsement. Fourth. I am, my lords, for the secretary of the Gram Panchayat, to which now, my lords, the election has on fourth, my lords. In fact, both the president and vice president have submitted their resignation. It is only now the vice president, that is the petitioner, my lords, who is now saying that his resignation ought not to have been accepted. Now, the section, my lords, very clearly says on the date when it is received. From there, my lords, it has to be reckoned 10 days and it ends on 13.
We have interpreted it by excluding that day. We have already passed an order, sitting here or Kalburgi. The date of submission would have to be excluded. 10 days will have to be counted thereafter.
But I'll have to verify that. I'll just go through that. Now, my lord, because the subsection 3, my lords, very clearly says that 10 days from the date of receipt of the resignation letter under subsection 1. So receipt, my lords, is on 4/12. He received the letter on 4/12.
And that voluntary resignation is withdrawing it.
That
you
is,
can't
my lords,
come in the way of that.
Fourth thing, your
that is, my lords,
proviso,
after
it is very clear. The assistant commissioner has to inquire.
If there is a threat, are you alleging threat?
There is no inquiry, nothing. Yes.
Are you
Yes,
alleging
Lords. In
threat?
the subsequently, I mentioned it, your worship.
It is resignation letter, my lords, which is now antedated.
Antedated, annakandre
Again,
next day I could
received on
not file
16.
it.
He says that he was under
ಒತ್ತಡದಿಂದ ಮತ್ತು ಬೆದರಿಕೆಯಿಂದ ನನ್ನ ಸ್ಥಾನಕ್ಕೆ ರಾಜೀನಾಮೆ ನೀಡುವಂತೆ ಮಾಡಲಾಗಿತ್ತು. The wordings in page 17, typed copy. Same day he passes orders. In the order he mentions on 14/12, there was an order that.
What was the requirement of passing this order if you say
That
that
was
it
not
has come
required.
into effect?
That was not required. The AC ought not to have, my lords,
Only
passed the order.
indicates.
No, but my lords, if he says he was under duress, no complaint.
No,
my lords,
ಅದಕ್ಕೆ date ಹಾಕಿಲ್ಲ.
16, my lords, date is there.
ಎಲ್ಲಿದೆ date?
AC, my lords,
ಎಲ್ಲಿದೆ date, Mr. Osmani?
Date and time, my lords.
ಮೇಲ್ ನೋಡಿ 12/24.
ಅಲ್ಲ, ಅದು blank ಇದೆ, but digitally signed, my lords, at bottom 16/12 ಅಂತ.
What was your so hurry that at 11:42 you passed this order as soon as he files that?
Lords, that is for the AC, my lords, to.
We'll direct the DC to inquire into this.
But my lords, the 10 days period, my humble submission, as per subsection 3 is concerned.
ಇದೆಷ್ಟೊತ್ತಿಗೆ ಇದಕ್ಕೆ ಟೈಮ್ ಬರೀಲಿಲ್ವಾ ನೀವು
ಇಲ್ಲ,
16 ಗೆ?
ಇಲ್ಲ ಬರ್ತೀನಿ.
ಇದಕ್ಕೆ ಯಾಕೆ ಟೈಮ್ ಬರೀಲಿಲ್ಲ ನೀವು? ಅದಕ್ಕೆ ಬರ್ದ್ರಿ ಟೈಮ್?
It is antedated, that's why, my lords.
No, antedated ಅಲ್ಲ, ಸ್ವೀಕೃತಿ ಗುಮಾಸ್ತ ಅಂತ ನೋಡಿ. ಬೆಳಿಗ್ಗೆ
16th, my lords.
12
Yes,
received. ಇದಕ್ಕೂ ಟೈಮ್ ಬರ್ದಿದ್ರೆ ಅದನ್ನ ಸರಿಯಾಗಿ ಹಿಡ್ಕೊಳ್ಬಹುದಾಗಿತ್ತು. 11:41 ಕೊಟ್ಟು 11:42 you have passed an order.
10 days, my lords, subsection 3.
Don't try to get rid of people by doing these kind of things. Petitioner is before this court seeking for the following reliefs. The petitioner admittedly was the vice president of the ಯಾವ ಪಂಚಾಯತ್?
ಕೊಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತ್.
ಕೊಹಳ್ಳಿ ಗ್ರಾಮ ಪಂಚಾಯತ್. The petitioner he stated to have submitted a resignation letter on 4/12/24 to the second respondent assistant commissioner. Thereafter, the petitioner, under a letter dated 14/12/24, submitted on 16/12/24, had sought to withdraw the resignation on the ground that the resignation letter had been submitted under threat and coercion from the Gram Panchayat members. Despite the said letter having been submitted, second respondent assistant commissioner, by way of his order dated 16/12/24, passed at 11:42 a.m. as accepted. The said resignation. It is challenging the same. The petitioner is before this court. Shri Jagdish Patil, learned counsel appearing for the petitioner, submits that firstly, the petitioner has 10 days time to withdraw the resignation submitted in terms of subsection 3 of section 48 of the Karnataka Gram Swaraj and Panchayat Raj Act 1993. The resignation letter having submitted on the 4th of December 2024, 10 days expired on 14th December 2024, 14th being a second Saturday and 15th being a Sunday, when the office of the second respondent was closed on account of public holiday. The withdrawal letter was submitted in the forenoon session of 16th December 2024. The public holidays would have to be eschewed for consideration of a period of 10 days as prescribed under subsection 3 of section 48 of the Panchayat Raj Act. Shri Prashant Osmani, learned counsel appearing for respondent number 3, submits that the period of 10 days would have to be calculated from the date of receipt of the resignation letter by the assistant commissioner or by the Adhyaksha. The resignation letter having been submitted on the 4th, the period of 10 days expired on 13th. And since no withdrawal was made by 13th, the question of referring to and contending that 14th and 15th were holidays would not arise. Since the withdrawal was not made by 13th December, the same automatically came into effect and the petitioner's resignation stood accepted in terms of subsection 3. Subsection 2,
3 of
the subsection 3 of section 48. Heard so and so peruse papers. This short question that would arise for consideration, the points that would arise for consideration are as under. 1. Whether for the purpose of calculation of period of 10 days prescribed under subsection 3 of section 48, the date of receipt of the resignation letter would have to be taken into consideration or would have to be excluded? Question mark. 2. Whether there is a requirement on part of the assistant commissioner to inquire into the cause of resignation and satisfy that the resignation has not been submitted under threat, coercion, or undue influence and allurement. 3. What order? Section 48 of the Panchayat Raj Act 1993 is reproduced hereunder for easy reference. Answer to point number 1. Next answer to point number 1. A perusal of subsection 3 of the aforesaid section 48 would indicate that every resignation made under subsection 1 of section 48 shall take effect on the expiry of 10 days from the date of receipt by the Assistant Commissioner or the Adhyaksha, unless within the period of 10 days he withdraws such resignation by writing under his hand addressed to the Assistant Commissioner. In the present case, the resignation letter has been submitted on 4th, is stated to have been submitted on 4th December. The contention of Shri Prashant Osmani is that the period of 10 days would have to be calculated from 4th December, which would expire on 13th December. The resignation has been submitted on 4th. A perusal of subsection 3 would indicate that the period of 10 days is to be calculated from the date of receipt by the Assistant Commissioner. The 10 days obviously would not include the date on which the resignation was submitted, since the usage of the words is inverted commas from the date of receipt. The word from would only mean that the 10 days would have to be calculated from the day from the next day after the receipt of the said resignation, and not on the date itself on which the resignation was submitted. In that view of the matter, I answer point number 1 by holding that the period of 10 days prescribed under subsection 3 of section 48 would have to be calculated commencing from the next date after the date of submission of the resignation letter. Answer to point number 2. The proviso to subsection 1 of section 48 reproduced here and above would indicate the second proviso to subsection 1 of section 48. The second proviso to subsection 1 of section 48 would indicate that on the receipt of a resignation letter by the Assistant Commissioner, the Assistant Commissioner shall inquire into the cause of resignation and satisfy that the resignation has not been submitted under threat, coercion, undue influence, and allurement, and is submitted voluntarily. Therefore, it was a requirement on part of the Assistant Commissioner to cause this inquiry, irrespective of whether there was any allegation made in this regard by the petitioner or not. Without causing such an inquiry, the Assistant Commissioner could not have passed the impugned order accepting the resignation. This also clubbed with the fact that on 16/12/2024, the petitioner had submitted a withdrawal of the resignation, a letter withdrawing the resignation on the ground that there was threat and coercion exercised by the other members of the Panchayat. Firstly, there was a duty cast on the Assistant Commissioner to cause an inquiry before accepting the resignation, irrespective of any allegation made by the person who has tendered the resignation. Secondly, when a specific statement has been made by the person tendering the resignation that there was threat or coercion under which the resignation was submitted, the Assistant Commissioner was duty bound to cause an inquiry thereto. The said letter having been submitted on 16/12/2024, the Assistant Commissioner, without causing an inquiry, in post haste, has accepted the resignation. Post haste has accepted the resignation by an order passed on 16/12/24, at 11:42 AM. They said acceptance does not inspire any confidence. An aspect of resignation from an elected post is a serious issue which ought to have been taken seriously by the Assistant Commissioner and necessary inquiry held as provided under the second proviso to subsection 1 of section 48, which has not been done. In that view of the matter, I answer point number 2 by holding that so and so. What order? In view of my answer to point number 1 and 2, the above petition is allowed and I pass the following order. Writ petition is allowed, a certiorari is issued, so and so at annexure D is quashed. The withdrawal of the resignation letter, the withdrawal of resignation dated 14/12/2024, submitted on 16/12/24 is accepted.
Yes.
IA1 does not survive for consideration.
38, Padmaja, Tatpatri.
Pass over. Yes,
39.
we'll come back.
My Lordship, serial number 43, my Lordships.
43.
My Lordship, there are other two matters arising out of the same suit. They are not listed. This may be listed next week, my Lordship.
Connect with so and so and relist on 22nd.
Much obliged, my Lordship.
Serial number 64.
64.
I have to file the statement of objection.
Counsel for the respond number 5 seeks for and is granted. Esdina beko. A week's time to file a statement of objection. Objections if any by 17th, relist on 22nd.
Serial number 41, short date may be accommodated, 1 week time.
ಯಾರಿಗೆ ನೀವು MB ಕಣ್ವಿ ಅವ್ರಗ ಬೆಳಗ್ಗೆನೂ ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ
List number 2 does.
List number 2.
2 does.
Number 2.
41.
List number 2, serial number 41. At the request of counsel for respond number? ಎಲ್ಲರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
I am respond number 11, sir.
ಎಲ್ಲರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
Inform madin.
Respond number 11, relist on 24th January.
My lord, serial number 76, my lord, first list. Serial number 76. On behalf of Gurudev Gachman, I am respond number 2, my lord. 2 weeks time, my lord. I am statement of objection.
Informed everybody?
Yes, my lord.
Petitioner in that.
76 at the request of counsel for respond number 2.
Yes, my lord.
76 Sri M.A. Olial has entered appearance for respond number 2, relate the name of S.B. Sheikh as that appearing for respond number 2. 76.1, Olial
Yes,
has entered appearance, delete Gurudev Gachinmat.
Yes, my lord.
At the request of counsel for respond number 2, relist on 24th January.
Serial number 53. Petitioner. I requested on 22nd. Counsel for respondent is present.
53 at the request of counsel for the petitioner.
Please.
Relist on 22nd.
22nd list, my lords, 26 and 46. My lord, there is a possibility of compromise, my lords.
Erroraluna.
Erroraluna.
26
and 46, my lords.
List 2, serial number 26.
And
notice issued to respond number 5 and 6 has been returned with the endorsement refused. As such, service in respect of respond number 5 and 6 is accepted to be sufficient. Registry is direct print the name of respond number 5 and 6 with the endorsement refused. Learned counsel for the petitioner submit that there is a possibility of settlement given 2 weeks time.
Yes. IPF for
Will endeavor to report settlement. Relist on 30th January.
Serial number 47, second.
46 also same, my lords.
46 connected, huh?
Connected.
46 connect to so and so. Submit that so and so.
Serial number 47 in second list, my lord.
47. Yes, Mr. Latkan.
Any date other than tomorrow, my lord.
Other than
personal inconvenience.
Counsel for the petitioner relist on 24th.
Please, any day.
I request 48, your lordship, next week. Please to. On behalf of PN Hattie.
At the request of counsel for the petitioner relist on 24th.
Please, highly obliged.
Your lordship, 74 and 75 in list 1, both are connected matters. Any short date,
74, 75 connect to each other.
please. A short date may be given in the
At
next
the
week.
request of counsel for respondent
Please respond.
Relist on 24th.
Please, and 78 also, your lordship. This matter also.
28 inform ಮಾಡಿದಿರಾ?
Please, I'll inform.
At the request of counsel for respond number 4 relist on 24th.
68 members.
One submission, your lordship, sorry.
58.
I'm for petitioner.
Interim order.
The date may please.
At the request of counsel for the petitioner 24th.
Please, your lordship.
Interim order
68.
68 interim order earlier granted is extended till next.
The matters which I have sought adjournment, they have a privilege of interim order. Kindly that may be
How is the serial
extended.
number
74, 75 and 78.
74, 75, 78 interim
Please.
order earlier granted is extended.
Grateful.
76 interim order is operating.
76 interim order.
ಮೇಡಮ್ ಮಾಡೋಣ. ಹೌದು ಇಲ್ಲೇ ಇರ್ಬೇಕು. ಇದು ಎಲ್ಲ ರೀಚ್ ಮಾಡ್ತಾರೆ 6 ಗಂಟೆವರೆಗೂ. ಎಷ್ಟು ಗಂಟೆ ಹೇಳಿ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಯಾವತ್ತು ರೀಚ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ನೋಡೋಣ. ಒಂದೇ ಫಸ್ಟ್ ಇಷ್ಟ ಮೇಡಮ್ 5-2
serial ಎಷ್ಟು ಫಸ್ಟ್ ಮೇಲೆ 5
ಕ್ರಿಕೆಟ್ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ. ಯಾವ್ದು? ಹಾ
ಕೆಳಗೆ
Malats, the honorable court is not visible or audible, if I may please. Malats, the honorable court is not audible. It's audible now. Malats, it went back again. It's off again.